Wait, please, your lordship. Lordship, I beg your lordship's indulgence to mention item number 45, lordship. It's a pre-arrest bail application. I'm on interim. Possibly some report they have received, but the FIR has not yet been registered. Lordship, may the matter come up next week, my lord. The senior counsel would be appearing, and we also would like to bring some further documents on record if required. Interim may be continued, my lord.
45. Abstention. On
29.
My lord, the interim earlier may be continued. Deeply obliged, my lord.
Hey, please, my lord. With regard to item number 15, my lord, today, I seek some accommodation for the day, my lord. Personal difficulty, my lord.
1-5.
Interim order passed earlier may kindly continue, my lord. One. TCR is also not there, my lord. Other side has also not appeared, my lord.
Prayer of silence will list the matter again on interim order passed earlier to continue.
Interim order passed earlier to continue. Deeply
May I
obliged.
mention item 52, lordship?
Yes.
Lordship, a bizarre case of fraud and perjury on this court. I pray for upgradation of the matter. If my lords can kindly take it up at 2, lordship. Lordship will be surprised to see the fraud on this court. Item 52, lordship.
All right, at 2.
Highly all right, lordship.
Right, please, your lordship. Lordship, I am praying for listing of a regular bail application, my lord, for today, my lord. As item number 28 is same FIR, my lord, same CD is lying in the court, my lord, today. That's smart. Deeply.
May I, lordship, I beg to mention item number 29, my lord.
Yes.
29, my lord, I am on interim, my lord. So what has happened, my lord, the erstwhile this FIR was registered as Rota PS case, my lord. There subsequently it has been transferred to Dispur, my lord. So a new PS case has been registered under Dispur police station, my lord. We need to ascertain the police station case number and file an application for to bring on record that case number, my lord. Praying for 3 weeks time, my lord.
Interim is there.
Yeah, there is interim, my lord.
CD not received, my lord.
Perhaps.
But inspired.
Yes. Dispur.
Regarding that, I have no instruction.
As per my instructions, my lord, it has been transferred from Rota to Dispur, my lord. So we have to ascertain the PS case.
But they have to give us
3 weeks time, my lord, we will file the application, my lord.
Right.
Obliged, my lord.
It please your lordship. My lord, I beg to mention item number 17. My lord, engaged counsel Mr. N. Hassan is unwell. My lord, may grant a small accommodation.
All right.
On 29th, my lord, may we please.
Yeah.
Obliged.
Lordship, I beg to mention item 42, lordship. Lordship, connected matters are fixed on 27/7, lordship, on coming Monday.
All right, 26.
Lordship, there's an interim, lordship.
Interim to continue.
You oblige, my lord.
Wait, please, your lordship. Lordship, I beg to mention item 34. Be taken within the next week, lordship.
34 CD received, my lord.
And here, lordship, a 35(3) notice has been given, and petitioner has.
34
We are going to
pending.
file an additional affidavit
My lord,
next
34,
week along with the affidavit, lordship.
34 pending since long, my lord. Earlier also adjourned, my lord. CD, otherwise we have received the case then.
Next,
Let the item be called up, we'll see then.
lordship. Please, your lordship. Lordship, I beg to mention item number 18. Lordship, kindly matter may be adjourned for a week.
Prayer. The matter again on
18, no?
Please, lordship. I beg to mention item number 41, lordship. In the matter, CS has been filed. We are on interim, lordship. Charges has been filed. We are on interim. 41.
what do you want now?
Lordship,
What do you want?
like to appear before a trial court with a protection. lordship.
To withdraw. You want to withdraw this?
If withdraw, I may be protected, lordship.
Then let the matter be called up. Is this a time to mention this?
Obliged.
Made his lordship. Petitioner was earlier in bail. Thereafter, he was participating in the trial proceeding. Meanwhile, some default, like 4 occasions, he could, because of communication and other factors, and subsequently, due to the force in NBW, he has been taken into custody, lordship. And later, after long time, charge sheet has been filed, lordship. FIR is of 2015. Thereafter, I have annexed almost from all the orders, lordship, for lordship's kind perusal. The order sheet will reflect, lordship. He will participate, lordship. Due to his financial constraint, he had to work. There was some communication gap, lordship. Lordship may peruse page 29, annexure 6, lordship.
POSCO is also.
Lordship, 10/5/2024 order, accused Meher Ali has appeared before the court, file petition so-and-so, allowed to go on bail, hard so-and-so. Charge sheet is submitted against so-and-so, showing as absconder in this respect, submitted on behalf of the petitioner. CS is submitted against the, showing him absconder. He has not wanted by police at any point of time, and he was very available in his given address. It is further submitted, the accused is released on bail, and this perusal found that the accused local person, CS, has been submitted on 31/5/2000, and same has been received in the court on 10/11/2023, lordship. And thereafter, lordship, he was present in the second page, lordship. It was fixed on 25/7/2024 for CC. The next page, lordship, 31. He is also again present. Charge has been framed, lordship. And 29/24 was fixed for evidence, lordship.
Page 56, on the strength of NBW.
Yes, lordship. That is my case, madam. My petitioner will cooperate.
I heard learned counsel for the petitioner and this is an application under so and so. The petitioner herein has been arrested on the strength of NBW, arrested on 21/06/2026 on the strength of NBWA issued by the learned additional CJM Kamrup because of his absence on several dates without steps. Charges have been framed and trial has also commenced. But subsequently, it is submitted the petitioner lost contact with his advocate. Also because of financial constraints, he could not before the learned court. Full stop. Earlier, he was granted bail. It is submitted that from now on, the petitioner shall regularly appear before the trial court, cooperate with the trial. Having regard to the above, the prayer for bail is allowed. The petition on bail of rupees thousand with two sureties of like amount. The satisfaction of the trial court connection with the aforesaid petition stands dispute of according.
Your lordship may kindly come to page 58, my lord. Once 58 of this petition, my lord. Considering the facts and circumstances, the accused Meher Ali is allowed to go on bail of rupees 20,000 with a suitable surety of like amount. In default, remanded to jail. That is, the bail order is already, he was granted bail in page 58 by the trial.
Which date?
Petition, my lord, page 58 of the petition, my lord. Detailed order is not available. Page 58, my lord. Last page, my lord. One portion.
This is 24 order. Not
That is
recent
the earlier order
order.
when he was granted bail.
Granted bail.
Thereafter, he was arrested.
Thereafter,
One page is available, my lord. Date
it
24.
was given. Earlier order.
Yet নাই এটা petition খন only এটা page আছে এটো মই
That was earlier order. Date is there, lordship. Date is reflecting 24.
But in my petition, my lord, no date, my lord, nothing is there, only that.
No, it just says, yes, you have to annex only the last page of the order.
Yes.
There is no date, nothing is
Yes,
mentioned.
petition.
It is taken, eh?
Petitioner was earlier granted bail. What is the date of this order? Are you aware?
Yes, lordship. 24. 27/6/2024.
No, that was the date, next date fixed.
Next date fixed on 27/6/20.
This is
24.
continued. 21/6/2024. Page 56.
No. This 26 order.
Yes, lordship.
It must be 2206. No, that is not available here. Anyone?
One page, last portion of the order.
Wait, please, your lordship. Lordship, it's a longish FIR, my lord. I'll just sum it up, my lord. What had happened in this case, a politician from Arunachal Pradesh is the informant in the present case. He says that he has given around some few crores to the elder brother of the petitioner for purchasing some properties in different places at Gauhati. And those properties were eventually he found that those properties he has not purchased and he has misappropriated the money. Now, my lord, the FIR was lodged in the month of April 2026. And the manner in which the arrest of the brother of the petitioner, whose name is nowhere in the FIR, no whisper, my lord, regarding him, my lord, he was arrested at 1:40 a.m. in the night on 14/7/2025. After almost 4 months, he was arrested at 1:40. He was never absconding. Now, my lord, this politician, when he came to the house before lodging of this FIR, he came to the house of the petitioner and threatened his old parents that they will have to bring their elder brother who is absconding, my lord. Otherwise, he will take action against them. My lord, will kindly come to page 35 once, my lord. Page 35 once, my lord. My lord, this is an anticipatory. My lord, is there at page 35?
Yes.
My lord, apprehending that, because, my lord, since they were threatened by a politician, apprehending that, they approached before this honorable court by filing an anticipatory bail application. The father, who is a retired teacher, and this petitioner number 2 is the present petitioner. This honorable court, on a prima facie satisfaction, have passed an order, because we are not sure whether any FIR was lodged, that no coercive action to be taken against the petitioners. Now, my lord, and subsequently, my lord, a report was called from the Jalukbari police station. Now, on the next returnable day, what the police conveniently done is page 39, my lord, will see. They have filed a report. They say that no such FIR is in the name of the present petitioners. And this order, page 39, my lord, will see. And based on that report or of the police, my lord, the anticipated bail application was closed and the interim was vacated because there is no apprehension. Because the name of the informant figures in the interim order. Now, my lord, 14 days thereafter, suddenly this FIR surfaces. This FIR surfaces 14 days thereafter. Pursuant to that, my lord, the parents of the petitioners were initially arrested. This honorable court, in a regular bail application, gave interim bail to the parents of the petitioner, which was subsequently made absolute by order dated. My lord will find that at page number 41, 19/6/2026. Now they have targeted the younger brother. If there is anything against the younger brother on the same ground, the younger brother at 140, there are two female members were present, the 25 years old sister and a 54-year-old mother at 140. My lord, I asked this question to myself, is it a case where at 1:40 a.m. in the midnight, only because the informant is a politician, the entire police team will barge into the house of into the houses of citizens where there are two female members? Nothing against this petitioner. This is a pressurizing tactic. Anticipatory bail was conveniently closed. Ten pages forwarding report.
Yes, PP.
Yeah, otherwise, from the page 39, he has pointed out that at that point of time, one report was called for, and thereafter, after 14 days, one FIR laws. Well, when report was called for at page 39, in fact, at that point of time, there was no case registered against the petitioner. Accordingly, I have received the report and pointed out that at that point of time, on that day, no case was registered against the petitioner. Thereafter, after 14 days, after made inquiry against the accused persons, finding some materials, case has been registered against the accused persons. Yes, from the FIR, it reflects that, my lord, one main accused is against one Saurav Kumar Jha, who is the brother of the accused, the present petitioner, and present petitioner is the co-accused, my lord, your lordship, at page 8, my lord. Because the allegation is that the main accused person, he has duped an amount of rupees, my lord, 10 crores from the, he has fraudulently taken from the complainant, and thereafter, my lord, those amounts were used for, my lord, for purchasing various properties and invest in various other businesses, my lord. And from the page 28, serial number 3, the nexus or links through which the amount of money rupees 10 crores was fraudulently taken from the complainant was committed by the Saurav Kumar Jha in strong connivance with Akshay Kumar, the present petitioner, and his other family members.
So the word strong connivance, that English word is the link.
Saurabh Kumar Jha not yet arrested. Main accused Saurabh Kumar Jha not yet arrested.
Well, what is the date of your arrest?
My lord, my date of my arrest is 14/7/2026.
14/7.
Yes.
Okay. Let's have the CD because there is plenty against you in the forwarding report as well. So
My lord, the forwarding report is prepared, save and except some English language, my lord, there is no material. What they are essentially trying to pressurize the family member to nab Saurabh Kumar Jha. On the same grounds, my lord, the parents were also arrested on the same ground. Nothing, not even an inch more than that. My lord, an investigation rather is required to be done on the source of income of that man who claims himself to be a politician and have invested this amount of money with the brother of the brother. An investigation rather is required to be done in that direction. Only because he's a politician. Is it a case, my lord, I am humbly submitting, where the police personnel will barge into a house where there are two female. Now the sister who is an MTech graduate is scared. Item number 5 is her anticipatory bail. Now the sister, the entire family is traumatized because of this police high-handedness. Father is a teacher. My lord, this well can be given a notice. He would go to the police station. 4 months he was in his house. There was no requirement. He would have gone. He was given his statement.
A short date I can produce the CD on 29.
29 is short date. Manu, apne nije sakna.
28.
Right,
Fix
no,
on-
Jalukbari, my lord, handshake distance.
all right, Monday.
My lord, I'm subject to, my lord, because, my lord, I have a strong apprehension from my instruction that police are not going to send case diary soon. So at least they should ensure that the case diary is produced on Monday. My lord, because these are the things which I am getting feedbacks from my clients. Because their police are getting involved in this case.
Earlier also, my lord, after perusal of the CD, 2 persons were already granted bail by the
Interim was given to them.
I will try to get it on CD.
Without CD, interim was given to them.
I will produce it on Monday.
Interim was given to them without CD.
I will try, my lord, but I cannot assure that whether police.
All right, we'll consider the interim if CD is not
Yes,
produced.
on Monday, if CD is
That
not
observation, my lord, will kindly reflect, man.
IO is directed to produce the CD on so and so without fail. In the event CD is not produced, the prayer for interim relief shall be considered.
Deeply obliged, my lord. My lord, item 5 is for the sister antecedent bail. This girl, MTech graduate girl, she is mentally traumatized, my lord. I'll show this. That we'll see that, my lord. Scared, and she's residing in some relative's house, my lord, a young 25 years old sister. Because the way police is behaving now, even she is scared. This is her educational certificate, my lord, we'll see on the left. This is the sister, elder sister.
Before you blame the police and the others, first blame your own brother.
My lord, my brother, my lord,
He is the source of everything, all this.
the informant, my lord, why, how couldn't the
Why would he go after you? Why would he go after this fellow? For no reason. Unless you
time
have
is
taken
better.
his money and cheated him. Aren't there any other people in this whole town to go after?
That is precisely, my lord,
What is his point in a politician from Arunachal Pradesh to go after you?
it is a dealing between that elder brother and
Yes.
that politician.
We are getting a very good idea of the dealing.
There is a sister, my lord, and that's the education zone.
Against sister, there is nothing, I think. Learned counsel for the petitioner. NLPP decision application under so and so. Sarah, the CD of the case has already been called for in connection with AB 1637 of 2026. The matter again on Monday along with 2026, where having regard to the contents of the FIR, it is provided that in the event of her arrest, the petitioner so and so shall be released on interim bail of rupees 20,000 with a surety of like amount to the satisfaction of the arresting authority.
I'm deeply aware.
May it please your lordship. Lordship, regular bail application under the POCSO Act, in fact, was, my lord, rejected a month ago by your lordship. So lordship, at this stage, my lord, the case diary may be called for and I'll issue notice to the mother of the victim, my lord.
CD and notice.
Lordship, some development is that may I pray for a short possible date, as possible as by honorable, say 30th or 31st, if it's convenient for my.
31/7.
31/7. Deeply obliged, my lord.
Please, your lordship. 482 application, lordship. Dear lordship.
Yes.
FIR is at page 11, lordship. May I read the contents, lordship? Because. Sorry, page 18. Annexure 2, lordship.
Ivor, I got to argue করছিল কে ছিল নাকি টু আছিল নহয় that case number in I have mentioned na AB 2004 of 26, huh? Item number 2. Give the number of item number 4. That's not the one. The order in item 5.
Lordship. Page 18, lordship, is the FIR, lordship. May I read the contents? With reference to the subject cited above, I have the honor to report that today on 14/7/2026 at about 9:24 a.m. a source input was received by the officer in charge Boishistha Police Station regarding illegal transportation of PDS rice from Barpeta to Meghalaya in a truck bearing registration number so and so. Accordingly, a general diary entry was made by Boishistha PS case number so and so. I was directed to take necessary legal action. In compliance with the direction, I, along with the staff, proceeded to Lalmati and conducted Naka checking. During checking, the aforesaid truck was intercepted at Lalmati so and so at about so and so PM. Upon inspection, 200 bags of PDS rice were found loaded in the vehicle. That driver failed to produce any documents relating to the lawful possession of sale, purchase, transportation of the said rice. The driver was apprehended on the spot and identified as so and so. The truck bearing registration number along with 200 bags of suspected PDS rice believed to be government property was seized in accordance with law. One mobile phone so and so. During preliminary, it has come to light that the apprehended driver, in conspiracy with them, with other associate, was illegally transporting PDS rice for unlawful commercial gain, thereby causing wrongful loss to government and depriving genuine beneficiaries of their entitled food grains under public distribution system. And accordingly, lordship, this case has been registered as 262 under section 612305 E 317 BNS read with 7 of EC Act. Now 7 of EC Act is available. The rest of the sections are not applicable in the context of my documents. Now next page, lordship, 20 may kindly be seen. 20. Before that, lordship, petitioner's trade license and GST certificate is from page 14. Is petitioner's trade license, that is Asia Traders, Nij Bagbor, Barpeta, and lordship GST at page 15, lordship, Isha Traders, petitioner. This is the GST certificate at page 15 and page 20. 20 and 21 are the two document, lordship. This source of this is in fact PDS rice, lordship. This has been availed by petitioner through e-tender process.
Yes, I am the owner. I have the documents.
Lordship.
Only, my lord, regarding that genuineness of all these documents, well, CD will reveal otherwise he has.
He can produce them before the ILO.
Yes, at least then
Lodge.
let him appear.
Learned counsel for the personal learned additional PP. This is an application. And so, as per the FIR, one truck loaded with 200 bags of PDS rice was intercepted. The driver was arrested, I think.
Yes, Lodge.
Driver was arrested. Where the petitioner is the owner of the state consignment of PDS rice as stated in the instant application. It is also committed that he can produce the necessary documents in time. There is no legality involved in the transportation of the documents in question been annexed to the instant bail application. Full stop. Call for the CD. That in regard to the above. That the petitioner shall appear before the IO within a period of 10 days from today. Along with all necessary documents. In the event of such appearance, till such appearance, and in the event of his appearance, yes, of his arrest, the petition will be released on interim 50,000 security of like amount would list again on so and so.
18.8.
Deeply obliged, Lordship.
This is a pre-arrest bail application law.
FIR not yet registered.
Questions, Lordship, police conducted raid in the house of the petitioner. Lordship, we could not trace out any FIR against the petitioner.
We will get a report.
Why is the police looking after you? You're not
That's what-
saying and you are not revealing anything.
So far, the Lordship allegation, we have no knowledge. Why search me, Lordship? But in respect of conducting raid, Lordship, we have made in para 2 and para 3. On 2 occasions, police conducted it in my house, Lord.
No, you say police thoroughly interrogated the family members of the petitioner. So you must know what is the interrogation about.
The police asked the Lordship, the petitioner's family members, Lordship, to produce the petitioner's Lordship. In respect of the petition, where the locations, in respect of they have, in the preemption is there.
Already had learned counsel for the petitioner and learned additional PP. Call for a report from the OC of what PS
Colophones prohibition.
as to whether any FIR has been registered against the petitioner. Is the matter again on
5th of August.
Till Lordship report, the police may not be.
So, my lord, let me get the report first, my lord, then I can get it on 3rd of August.
Say in the absence of any, it is made clear that in the absence of any case registered against the petitioner, the no coercive action shall be taken against him.
His lordship, conducting counsel is on legs sometime.
May it please your lordship. My lord, page 8 is the FIR, my lord. The pre-arrest bail, my lord. My lord, no one is named in the FIR, my lord. My lord, how I came to the picture, my lord. I'll try to apprise my lord. My lord, page 8 is the FIR. Here, my lord, some goods were stolen, my lord. The my lordship may kindly turn to page 18, my lord. Is a forwarding report, my lord. Forwarding report, page 18, my lord. Here the thieves, my lord, who have stolen those articles, they were stolen. They were arrested, my lord. Page 18, my lord, and relevant portion, my lord. Page 19, paragraph 3. During the course of investigation, my lord, the accused persons were identified, apprehended, and the stolen temples articles were recovered from their possession, directly linking them to the offense, my lord. These are the thieves, my lord. They have stolen the goods. They were arrested, my lord. Along with these thieves, my lord, one accused number 5, my lord, that is page 18, accused number one person, Proceedul Islam, was also arrested. Proceedul Islam was also arrested, my lord. Now, my lord, whatever, I am a, my lord, I deal in, my lord, metal business, my lord. I am a, my trade license, I have an act, my lord. So may kindly see the trade license. Is at page 14. Is at page 14. Then, my lord, page 15, my lord, is the GST bill, my lord. But when that procedural, my lord, he came with some, my lord, metal articles, my lord. But I have purchased it in white, my lord. I've given him a GST bill, my lord, page 15. The Rosidul has sold some, my lord, metal articles. Page 15. Page 16 is the bill, my lord, GST bill. Well, the residual name is there, my lord. So, my lord, I am a shopkeeper, my lord. I used to purchase old metal articles, and in lieu, my lord, I used to, my lord, give, my lord, new, my lord. And the stolen goods were recovered. They, my lord, from, and the thieves were also stolen, my lord, arrested. The person who has purchased from the thieves, he was also arrested. He has sold it to me, my lord. And I have, my lord, purchased it in white, my lord.
So he is the purchaser of those stolen
Purchaser, purchaser means second purchaser. First, they have sold it to Rosidul. Rosidul, sold it to me, but I didn't know, because I would have, if it would have been a stolen, I would have knew it. I would have not done it in white, my lord. I would have not given them GST.
That is precisely why you have done it in white.
No, my lord. No, my lord.
So that you can claim that you had no knowledge.
Yes, at this stage, my lord, CD may be called for.
My lord, lordship may kindly see, my lord, whether, my lord, no person will, my lord, her petitioner, he will never knowingly, my lord, purchase stolen articles from a temple, my lord.
Those, my lord,
response under Paul, my lord, he will never purchase, and he will, my lord, never purchase any articles which are stolen from the temple, my lord. Repents under Paul, my lord. I have a trade license. I'm a reputed businessman, my lord. And when sections also, my lord, does not attract, my lord.
From this,
One is, my lord, theft, and one is, my lord, trespass, my lord. Lordship, no, these sections are not attracted in case of me, my lord.
is well aware that those articles are stolen, my lord. 120 numbers of my lord brass sorai.
Yes, they don't just fall down from the sky, you know.
Yeah, but my lord, I have purchased it in white, my lord.
And my lord, I will have to ascertain from the
36
CD whether
kgs, 500 rupees. What is the rate, market rate of brass?
My lord, I have purchased it on, my lord, 18,000.
What is the market rate?
Because it is weight, my lord. Brass, my lord, it is that, my lord, if we sell it, my lord, that some persons, that ferry wallahs, they come to our house, my lord, to purchase old things, my lord. So, my lord, he's a reputed businessman, Ripon Chandra Paul, my lord, he will never do, my lord, any, my lord,
Be more
steal
than, my
any
lord,
articles.
more than 3,000, my lord, 4,000 rupees.
That is new one, my lord. So, my lord, kindly protect me, my lord, because I'm a reputed businessman, no direct allegation against me, my lord. And goods were also been stolen, my lord.
Market continues only because of this, my lord,
But
presence of this person.
I have given, I have not purchased it,
Of these
but I have
stolen
purchased
articles.
on my
Those-
white, my lord, given
Those
him a
articles
GST
were, my
bill.
lord, stolen from the
CD.
theft.
Call for us, but interim may be given, my lord.
Why should we give him interim? Officer, you appear to be in boots.
Then a short date may be fixed, my lord.
On 3/8,
My
my
lord, can it be next week, my lord?
lord, only minion. 41/7, my lord.
Obliged, my lord.
May it please your lordship. Lordship, in this case, what has happened, lordship? The petitioner has instituted a complaint under section 138 of the NI Act, lordship, against one Munna Shah, lordship, on 9/6/2026, lordship, which is at page 13, lordship. Page 13, lordship, NI case number 23 of 2026, lordship, annexure A, lordship. It was instituted on 9/6/2026, lordship. Thereafter, lordship, after lordship initial deposition of the petitioner, lordship, summons were issued against the said Munna Shah, lordship. Lordship, kindly peruse order dated lordship 11/6/2026, lordship, at page 23, lordship. Can I go through it, lordship? Complainant, namely Ramesh Gupta, is present before the court, that is the petitioner, lordship. The complainant has also submitted the initial deposition of complaint on affidavit, and same is considered as evidence. The documents were exhibited. Let the original documents be returned to the complaint and the compared copies be kept with the case record. And complainant is also directed to produce before the original documents as and when required. Upon perusal of the complaint petition, the evidence of the complainant and also the documents furnished, I am of the considered opinion that the court has jurisdiction to try the same, and the same is filed within the period of limitation. Hence, a prima facie case under section 138, read with section 142 of the NI Act, is found well established against the accused person, namely Munna Shah, being the proprietor of MS Roshan Store. As such, cognizance of the said offense is taken against him. Issue summons to the accused person, fixing for 10/7/2026 appearance of the accused person's offense explanation. So this Munna Shah, lordship. Thereafter, what had happened, lordship? This Munna Shah on 22/6/2026, lordship, lodged an FIR before the officer in charge Jamuguri police station, lordship, alleging that that particular check has been lost, lordship. So against and the same was registered as lordship 31 Jamuguri PS case number 59 of 2026, lordship. And against that FIR, lordship, the petitioner is apprehending arrest, lordship. It is a totally, lordship, make out case, lordship, to cover up this NI proceedings, lordship, instituted against that particular Munna Shah, lordship.
Case is proceeding now.
Proceeding, lordship, because the next date is fixed on, lordship, 6/8/26 for appearance, lordship.
Yes, PP. What is this NI case? And then he goes to
Yes,
lordship.
Only to create a defense, my lord, probably.
learned counsel for the petitioner. PP. an application under so and so. That the government had instituted a case against the present petitioner under the NI Act. Respect of a check issued by the petitioner for rupees 6 lakhs. Check amount is 6 lakhs.
6 lakh, Your Worship.
Which was dishonored. But surprisingly, the petitioner also lodged an FIR 2206/26 at Jamuguri PS alleging misuse of his check
Lordship.
with an intention to fraudulently withdraw his 6 lakhs. Submitted that the affair has evidently been lodged to build up a defense in the aforesaid case under the NI Act, which is proceeding before the learned magistrate. Call for the CD. In interim, it is provided that in the event of his arrest, 20,000 on surety. Just again on
19.8 mil.
Oblige, Your Lordship.
Wait, please, Your Honor. This is an anticipatory bail application. The Lordship will find the FIR at page 11. The petitioner number 2 got engaged with a girl. Marriage was scheduled in November, my lord. He broke, the family cancels the marriage, my lord, because they find out that the girl was in another relationship. Now this FIR is lost, my lord. No allegation of sexual abuse, only the breakdown of the marriage, my lord.
What is the meaning of this accused Noren Bora father? Whose father?
That is how they have written in the FIR, my lord. We have translated it. Father of the petitioner number 2. If your lordship sees the original at page 15, that's how it has been written, my lord. Noren Bora is the father of the prospective husband, Uditya Kumar Bora.
What is the section?
83 is, my lord, going through a marriage ceremony fraudulently, knowing that he is not lawfully married. But here marriage ceremony has not occurred. Secondly, this is non-cognizable, my lord, and prosecutable only on a complaint. Not attracted anyway. 296 is, my lord, the earlier of 294. That will also not be applicable because that happens only in a public place. And that is also bailable, my lord.
Sections may not be proper, but my lord, from the contents of the otherwise unfortunate incident at the last moment, my lord, cancel.
They must have discovered something about the girl.
Yes.
We don't also make any imputations, my lord.
Maybe, my lord, that anything may be, but my lord,
Maybe not about the girl, but about the family or whatever.
at the last moment.
We did not make any imputations, but we found out something, my lord, so we decided not to. And marriage is was scheduled in November. And if for breakdown of marriage, people have to be sent in jail, my lord. Half of India will go to jail, my lord.
But the petition and learn it. Additional PP. This is an application under so and so. The allegations as contained in the FIR, briefly put, is that marriage was arranged between the petitioner number 2 and the informant girl, And in this regard, a ring ceremony also took place, but subsequently, although the date of marriage was fixed, the petitioner family cancelled the marriage without assigning any reason. When the government side went to the house of the petitioners and questioned them, they were abused with obscene language. There are the cases registered under section 83/296/3 within bracket 5 BNS. So, however, the contents of the FIR itself prima facie there does appear to be any element of criminality. To the same, the prayer for pre-arrest bail is allowed. It is directed that the petitioners in the event of their arrest shall be released on bail of rupees 10,000 with surety of like amount section of the arresting authority. There are the observations made herein are only for the purpose of the investigation and shall have no bearing in any other proceeding.
Deeply obliged, madam.
Disposed.
There is no FIR in the case, my lord. The Lord, kindly see paragraph 3 and 4, madam. Five is present, my lord, 5 AM. Two times he was picked up, my lord, page 13. First agreement, one agreement was made within the two. Again, my lord, in other police station, he was again two times, my lord. Only let them bring whether any case is filed or not, my lord. This is the one.
So, police station is now marriage bureau.
But they did it, my lord.
Under what circumstances that happened, madam?
The petitioner. Additional people put from the OC of Bongaigaon PS.
No, please.
No, my lord.
Borpeta.
Borpeta Sodor.
Borpeta.
Borpeta Sodor.
Is there any has been registered against the petitioner? It is made clear that in the absence of any case having been registered, shall not harass the petitioner in any manner, take any coercive action against him.
For 8 minutes.
Obliged.
Appeal, sir, lordship. Anticipated a bail, lordship. FIR is at page, lordship. Page 18, lordship. Vernacular type is at page 11, lordship.
Lordship. Wife has lost the case, Lordship, against the husband and Lordship, the brother-in-law, Lordship. Section is Lordship 85, alia 498A, Lordship. Otherwise, Lordship, this FIR has been lost, Lordship, with a conspiracy manner, Lordship. Kindly, Lordship, is Lordship 20, Lordship. The petitioner number 1 has lost another FIR, Lordship, on dated 4/7/2026, Lordship. This present petitioner, Lordship, present informant, Lordship, she is escaping, Lordship, with some other person, Lordship.
Who escaped?
Wife, Lordship.
Escaped from what? Your custody?
Yes, Lordship. She is escaping, Lordship, with another person, Lordship. Matter of illicit relationship, Lordship. And in this regard, Lordship, I have lost an FIR, Lordship, petitioner number 1, Lordship, but police has not taken any action, Lordship. And 2 children are also there with the wife, Lordship.
What will police do? She has left you, they will drag her back to you.
Lordship, that is another.
Your wife, not your daughter.
Otherwise, Lordship, the son of the petitioner, Lordship, he was studying at Lordship, Hosai, Lordship. She has picked up her child from their, Lordship, informing false information, Lordship, to the management committee, Lordship.
They're supposed to issue notice, isn't it?
Yes, madam.
Specifically, Ernest Kumar is with regard to 498A only.
Yes. No, it's 85, yes, ma'am. Yes, ma'am. Regarding the allegation that is the on dated 26/26 regarding torture or physical.
There is registered under 498 as
And
85.
And Lordship, the other petitioners, Lordship, they are separately state, Lordship. They are married person. They have another.
It's the let them appear and CD may be confirmed.
Learned counsel for the petition and learned it. There is an application under so and so. Allegations contained in the FIR lodged by the wife relate to harassment and torture in and also demand for dowry. The case is registered under section 85 BNS. All for the CD. You have not received any notice.
No, Lordship.
Case is registered under section 8 BNS, but it is submitted that the petitioner have not received any notice under section BNSS. All for the CD. In the interim, it is provided that in the arrest 3108 order provided that the petitioner shall appear before the IO within a period of 10 days from for the purpose of interview. It is further provided that the petitioner shall not try to intimidate the victim or the other witnesses in any manner. Just again on
17/8.
Lordship. Yeah, please, Lordship.
Yes.
Yeah, please, Lordship. Lordship, the respondent, they have filed their affidavit on 18th of July. So I need some 4 weeks time to file my rejoinder, Lordship.
Learned counsel for the petitioner prays for time to file rejoinder to the affidavit filed by the respondent.
Your Lordship, I request to kindly fix a short date for it because since the review proceedings has stayed in the law, but all the proceedings has stayed.
Not
My interim is, Your Lordship, that may be continued.
asked earlier to continue till the next date of.
11th August.
Deeply obliged, Lordship.
Deeply obliged. Madam, something Lordship.
What is it for?
Lordship, the matter has come up for admission, Lordship, and initially there was a.
All right, you want after some time.
May I please? This is an application for quashing over proceedings so far the present petitioner is concerned. Here has been yes 13 people at charge sheet date in connection with the page 20 charge sheet. Page 20 is the charge sheet. I am sorry, my lord, FIR. May I read? With reference to the subject cited above, here the informant is the my lord district commissioner. Now earlier he was designated deputy commissioner of a district. With reference to subject above, I the informant that the revenue circle officers are most important field level government officers which maintain record of land belonging to government and private partners. These officers provide various citizen-centric service like mutation, such and such, issuing holding certificate, non certificate, etc. The services are very essential for general public, without which their land transaction will be held up. In order to strengthen the revenue administration in the state of Assam, the government had taken several initiatives. While addressing the conference of ADC Revenue Circle Officer and Attached Circle Officer, Honorable Chief Minister Assam strictly warned against any sort of irregularities and corrupt practice in the revenue circle. Regular complaints, media report, and source information have been received from time to time regarding large-scale irregularities and corrupt practice in the revenue circle offices. Several middlemen and unauthorized intermediaries are operating in the circle office, demanding bribes from innocent public in order to get the service delivered to the unduly influenced and public servant by exercising of personal influence. The officials working in the circle offices are actively promoting such activities and encouraging the middlemen to collect the bribes on their behalf for performing public duty. In several circle offices of the district, the corrupt officials themselves are engaging such undesirable middlemen to collect the undue advantage. Such corrupt practice are hampering the delivery system of revenue administration and causing severe inconvenience to the general public. Specific incidents that came to the light through information about involvement of some petition writers in such and such. So here basically allegation is that the officials are taking bribes for doing some official work through middlemen. This is the basic allegation in the FIR. No one is named. Your Lordship will find at page 22, a list has been annexed here. Suspected person they are suspected to be middlemen between the parties and the officials. 22%. Page 22, your Lordship get in mind. Here altogether 30 people named. My lord, get page 2. Altogether 30 names are there. So 27 at serial number 27 is the present petitioner. So on the basis of this complaint lodged by Deputy Commissioner, police case was registered and the matter was investigated. Out of 30, your lordship will find page 23 is the charge sheet. Police submitted charge sheet against altogether 13 people. Not a single person, my lord, including not a single officials who were the main culprit as per FIR were in this charge sheet, my lord. My lord will get page 23, this is the charge sheet, and relevant portion page 25. Here names your lordship will find. Second paragraph. So altogether, I given name serial number 1, 2, 3, 4, 5, 6, 7, 8, 9. Thereafter, another Iqbal Hussain also arrested in connection with this case, and a such and such was seized. And now, last 4 liner. In this case, namely Keshav Chandra Sahu, Tanjir Ali, and Shahjahan Ahmed Chaudhary obtained anticipatory bail from Honorable Gauhati High Court and appeared the police station. They were released. So 10 persons were arrested during investigation, subsequently released, and these 3 obtained, including the present petitioner, anticipatory bail, and they were released on anticipatory bail. Now, your lordship will find page 36. This is the anticipatory bail order granted of the present petitioner.
So if there is nothing against you, why not a discharge application instead of coming here? Why should we go through all the evidence or anything?
Legal action, my lord, because your lordship kindly peruse page 36 and relevant page 37. Here High Court categorical finding is there. Page 37, my lord, while granting anticipatory bail. Perusal of case diary in the middle, my lord. Perusal of case diary reveals that some witnesses have named some other persons. My lord, got it, my lord. Page 37, middle part. Perusal of case diary reveals
There,
that.
but we have to independently assess.
Why the name of the petitioner is not involved?
Should we go by that when the record is before us? This is a separate proceeding. We are not bound by observations in a bail application.
No, definitely not. Definitely not. But I am, my lord, relying this because it is a case, my lord. For the my first point is that allegation is wholly against the officials. Again, not a single official has been charge sheeted, my lord. Your lordship kindly note this point, my lord. The entire allegation taking bribe against officials of the circle officers and DC office. 30 people are said that they are suspected to be middlemen between officials and the public. Out of 30, 13 people has been charge sheeted. There is absolutely nothing, my lord, against, so it will be a abuse of the process, my lord.
Earlier occasion, respondent number 2 is shown in the also, lordship. Their appearance is not present. Cannot appear.
Government, GA Assam.
Let them appear, lordship. Thereafter, lordship may decide. Lordship also, because this person, including the other 2 persons, they are also under protection, lordship. They are,
No, there is no interim.
yes,
No, bail tasu.
they are on bail, lordship. If if he's questioning for the coming for questioning of the search state lordship, if it is quashed, the entire proceeding will go
No.
at this stage.
I am not praying for entire proceeding, only in connection with the present petitioner only. That is my specific prayer.
Lordship, not at this.
That is specific prayer. Prayer is that page your lordship will find. The whole cannot go on the basis of this prayer.
In the matter of questioning of the entire proceeding in respect of the present petition.
Yes, in respect of the present petitioner only.
The case is made out, lordship, as it has been filed after having found material.
In respect of the present petitioner only. So entire case will not
The
go.
petitioner is still under protection, lordship.
What you are essentially seeking is questionment on the ground that there is no material against you. For that, we have to go through the
Record is there, my lord.
material. Why should we go?
In that case, my
Why
lord,
should we carry out that exercise
now,
when
in
the same exercise can be carried out at the stage of consideration of charge?
Yes, that is my alternative prayer. Your lordship may dispose of giving me liberty to approach the court at the time of framing charge. That court will pass appropriate order if any application is filed in accordance with law.
Very good. Third learned counsel for the petition and learned additional PP. This criminal petition has been preferred challenging the proceedings in case number 5. For the learned
Additional Chief Judicial Magistrate Hujai.
it is the contention of the petitioner that firstly, he is not named in the FIR, and secondly, although the charge sheet has been filed wherein he has been included as an accused, there is no material against him respect of the alleged offences justifying a charge sheet against him. Question of whether there is any material to proceed against the petitioner be well considered by the learned trial court at the time of consideration of charge. Having heard the learned counsel for the petitioner, as well as learned counsel, learned additional PP, petition is disposed of with the direction that the petitioner may file appropriate application charge the time consideration of charge shall be duly considered by the learned trial court. Thereafter, appropriate orders may be passed. Record the petition stands disposed.
I am obliged.
Wait, please, your lordship.
Yes.
Should this a regular bail lordship, 9 months in jail custody lordship? Kindly peruse the last order that is on 25/3 order lordship. Ordinate bench has asked this petitioner to lordship after.
So the victim has been examined or not?
Yes, lordship, that was examined lordship. Have submitted additional affidavit lordship. Annex the copy of lordship. Is 32.
He's been examined.
Yes.
On record, I have not found lordship.
Is here.
Awesome, no?
How old is the girl? 16.
14 years, 11.
14
As
at
per
that time.
FIR 14 lordship,
11 months.
the mother's statement already been there lordship. I've annexed that also lordship. PW2 lordship.
So the evidence is against you.
It's implicated
But lordship, they have no objection lordship. That part is there. lordship.
Objection.
Yeah.
It is not for you to object or not to object.
Already lordship 9 months in jail custody lordship, only nine out of 9 witnesses, 2
Minor
witnesses has been examined.
14
lordship.
years, 11 months at the date of occurrence. Categorically
that-
implicated the 5 subsection 2. 2. 3 subsection 5 of BNS.
Submitted that the petitioner shall file regular bail application before the learned trial court. Where accordingly, the instant application ends closed with the observation that in the event of any such file, the same.
Item 20, my lord, I am in favor, my lord. Anticipated bail application, my lord.
Third learned counsel for the petition submitted that scenes. Will approach the trial court for regular bail. 6 protection till then. Accordingly, the present application is with the direction that the petitioner shall appear before the learned trial court within a period of 14 days from today. The event any application for bail is filed, the same shall be considered till the interim order passed in bail shall remain in force till the next 14 days or till the appearance of the petitioner, whichever is earlier.
Lovely.
Thank you, Minister. Can it be taken up after some time?
Probably in this case, when CD is not there. 22. Already we're at 58 days behind bars, man. I pray for a short date, man.
Is there not received?
3rd or 4th of August, probably, man.
All right, so did not receive list again on 4th of August.
4th of August, man.
Hello.
In this case, I would like to point out, I have received a report from the IO, my lord. This case, first sheet submitted, but my lord, one report from the IO that at the time of my lord filing this bail application, one Aadhaar card of the my lord victim was annexed in the bail petition, my lord. And now from the report of the IO, only to show that victim is a my lord measure, that Aadhaar card was manipulated by the accused person, my lord. And now that report along with the Aadhaar card, my lord, your lordship may kindly come to page 27 of the petition.
This document has been provided by the petitioner, Lordship.
That date
So
of
I
birth manipulated, my lord.
not aware about that, Lordship. As per they have annexed.
Obviously, it is provided by the petitioner. We are not saying advocate has given the
I
document.
have only
may
checked
kindly
the,
come to
this
page
number and I am not
27,
aware about that. What is the? Yes, sir.
Hey, it says alive, lord.
Okay.
That is, my lord, date of birth is shown as 28/8/2006, but in fact, her date of birth is 28/8/2011. Well, the report of the IO along with the original. That ground alone, my lord, this petition is liable to be dismissed. My lord.
Dismiss it because if they have provided the long term, they have misguided me, Lordship, also. Not even the court, Lordship. But is the report of the IO. The date of birth to भूले. नाम साम ठीक है ना?
सब ठीक है.
He's having.
Was heard learned counsel for the petitioner and learned additional PP submitted by learned additional PP that charge sheet has already been submitted by CS number so and so.
CS number 40/26 dated 29/6/26.
Furthermore, the IO has submitted a report. The officer in charge, Helm PS, Bishnut district, has submitted a report stating that the petitioner has Annexed a forged Aadhaar card pertaining to the victim, showing her date of birth as 28/8/2006. Whereas investigation revealed that the actual date of birth is 28/8/2011 as per original Aadhaar card. So obviously the petitioner has resorted to this act in order to show the victim as a major and thereby to plead the court. Having regard to the same, the bail application deserves to be dismissed. That count alone, the police may take up the necessary action in this regard.
Let's.
It is your lordship. The POXO matter, we have taken steps on 6th of July, my lords.
24, my lord, I am trying to get the instruction regarding service of notice, my lord. Till now, I have not received any.
It is here.
It is here.
No instruction is received.
Yes, my instruction regarding service of. Fix it day after tomorrow, on 24th Friday, I can try to.
That learned additional PP submits that report has been received regarding service of notice on the respondent number 2. Release the matter again on Friday.
My lords, on Tuesday, please.
Huh?
Tuesday, my lords.
Tuesday. Next week.
Yes, it's 28. Obliged.
Point.
If I may not case diary not received, no.
Yeah, please, your lordship. Lordship, in this bail application impugned, FIR is at page 30. CBR.
Where?
At page 30, my lord, please.
1-3.
1-3, your lordship.
Your Sahinur.
My lord, accused number 2.
Yes.
Accused
CD
number
is there.
1 already released on bail, your lordship. As on today, 65 days behind the bar. So considering the length of detention, only on suspension, your lordship is.
What is the offense?
They are involved in illegally, my lord, transporting
Yes.
Bangladeshi nationals to India, my lord. Without having any.
Then offenses are not charge sheeted.
Not such.
Right
Because
now.
I have no instruction regarding filing of.
60 days are over.
64 days, 65 days as on today, your lordship. In
What is
spite
the
of
statutory period?
Sometime I will try to get the
having
instruction.
sealed border and security forces.
At 2, my lord, I will get the instruction.
All right. But where is the release order of the other?
It's 18, your lordship. And relevant portion, your lordship, has page 21.
If the court below has released 1, why not 2?
My lord.
If the court has released 1, why not 2?
My lord, 2 was, in the meantime, he was arrested and.
Huh?
2 was
Both
arrested.
were arrested.
Both the arrested, my lord.
So 1 was released. Why was the other not released?
Has
on
not-
bail.
It has not released and he was not approached before the session judge. Directly he has approached before the Honorable High Court,
Oh.
my lord.
So he enjoys a higher status.
On the ground of violation of those mandatory provisions.
Where is your, you have not annexed anything, notice? Or you're not taking those grounds? Is there any 90-day offense here? No, I don't think so.
But maybe, sir.
61, 148, 336, 340, 318.
Starting at 2 p.m. my lord.
Published it. May I please, your lordship? Regular bail application, my lord. There has been shown arrest in this present case. He was earlier arrested in another case. During judicial custody of that case, he was shown arrest in this present case, my lord. FIR at page number 13. 15, my lord. Sorry. Allegation is that during Naka checking, my lord, 31.69 gram heroin has been recovered from the possession of one Sanwar Hussain. Accordingly, he was arrested and this affair has been registered under section 21B and 25.
Here.
Charge-sheeted case. Charge-sheeted case.
Here, search framed
Charge was
It
framed.
was, heroin, it was recovered from whom?
from Sanwar, my lord.
From
Sanwar. So he is before us now.
My lord, he is
Ramesh Chandra Vishwas. I was, in that period, I was in custody in another case,
This is item
26.
Ramesh Vishwas.
my lord. Promotional. Charge is framed only on 7/7/2026 under section, my lord, against him 29 NDPS, my lord. Other co-accused, my lord, it was 21B, 25, my lord.
Against me, 29. only.
29 NDPS. From the statement of the arrested, my lord, it
So
is
nothing was recovered from you.
not recovered, but my lord, from the statement of the my lord arrested accused, it was said that he is the supplier, my lord, and he sold it at rupees 1,26,000, my lord. From the present petitioner.
The statement of arrested accused person. For the police only.
One important thing is that, my lord, he was earlier arrested in several cases, my lord. Again, several cases are pending, my lord. Some Hauli, Borpeta, Tholai, that cases are also, my lord. Borpeta Road PS.
Those cases, my lord, I have been tried and I have been acquitted, my lord. Is the trial, my lord? Such.
Here, this case is intermediate.
Intermediate.
Against him 29, section 29. Charge him against him. 7/7/2000 search film. In the scan copy I have taken.
Other than co-accused, nothing is there.
My lord.
But learned counsel for the petitioner and learned application under so and so. As per the allegations in the FIR, receipt of prior information on 15/4/2026. One Anwar Hussain was intercepted and 31.69 grams of heroin was recovered from him. What is commercial quantity? 50.
Fine.
And in course of investigation, the present petitioner was
250 minutes. 250.
course of investigation, the present petitioner was also arrested on
Arrest on, my lord. 12/5.
12/5 minutes.
12/5/26. Currently, the completion of investigation charge sheet has been submitted and charge has also been framed under section
Against me 29, my lord. Against me 29.
Or others, my lord, under section 21B, 25/25, and just against him, my lord, 20.
charge has been framed against the present petitioner under section 29 of the NDPS Act. Perusal of the CD, it appears that the petitioner was arrested on the basis of statement of the co-accused. But recovery of any contraband was made from the petitioner and there is no other material against him.
Earlier also he was arrested, man. That is, and it is reasons, man.
Petitioner was earlier arrested in connection with
And in remand, man, one flag mark is there, man.
in Borpeta PS case number 40 of 2026.
I will leave 125. 23.
He has annexed this Borpeta PS 40 of
Borpeta road, my lord.
2026.
Another, my lord, in the scan copy there is. I will leave Borpeta.
Where he was released on bail by this court by order dated 19/6/2020 in BA 1326 of 2026. An additional PP submits that was also arrested in Howley PS case number 125 of 2026. July PS case number 41 of 2025.
Borpeta
And
77.
Borpeta 116.
77, man. 77 of 20.
Bail order it is Borpeta PS 116 of 2026. As reflected in page 52.
Fine.
Second, para 8.
That case, he was earlier arrested. Other case, he is acquittal.
He will say he is involved in several cases, my lord.
Para.
Although he is acquitted, my lord.
However, since the present case relates to intermediate quantity, the rigors of section 37 are not attracted and therefore the prior involvement of the petitioner in similar cases are relevant inasmuch as there is no other material except the statement of co-accused to implicate the petitioner. As held by the Honorable Apex Court, P. Krishna Mohan Reddy versus State of Andhra Pradesh. The same is sufficient to deny bail to the petitioner. Of the above, prayer for bail is allowed. Subject to the following conditions. Case 55. Conditions kita dia. Obliged.
My pleasure, Lordship. The allegation in the FIR is basically possessing of counterfeiting of notes. So before going to the marriage, my lord, I would like to your lordship attention at page 38, that is the ground of arrest under section 47 and that is under section 48 to the relative. So that was given at page 38, my lord. So that was written only in English language. So if your lordship will look at the signature of the relative, she has just put the thumb impression, right thumb impression. So there was nothing in the notice that has been read out to her or and make her understand that. So as per the judgments in a catena of judgments of Honorable Supreme Court, mandated that at least there should be a vernacular column.
If you cannot read and write, then what is the point of giving you in vernacular or English? Everything is same to you.
But to that extent, it is Malat in this case there are material Malat on 28/6 on the same day, as per the note of the IO Malat at 2:15 p.m. Malat. Just I am reading 2 line Malat, as he is not going to the marriage Malat.
I am going to the marriage.
Yeah.
Before going to the marriage, I am submitting this.
I have served the notice under section 47, whereas to the accused person so and 48 to the relatives, stating the ground of arrest, also briefed them in Assamese and Hindu language. although the accused person stated that they have no English language. The relatives oblique friends of the accused, Ziaul Haq and Anna Ali, have been informed the ground of arrest by serving notice 48 and briefed the grounds to her in Assamese language and to the Rahim Ali in Hindi language. So, the language they have understood.
So, my lord, mere stating in the CD doesn't suffice because.
What will suffice?
Because they have to retain in the notice, my lord, that was read out to her. And even in the 47 notice, that was also in the English language. So the person couldn't understand English, my lord.
Yes, put his signature in English.
That's as because he can put signature, that doesn't mean that he can understand the language, legal language. That one ground, my lord. And next, my lord will kindly have a look at the FIR, my lord, at page 16. May I read, my lord?
Just a moment.
Page 16, my lord. So no possession is there. It is apparent. My lord, I'm reading, my lord. Today on 27/6/2026, based on a reliable source information, it was learned that certain persons were engaged in the printing, manufacturing, possessing, and circulation of fake Indian currency notes in Millennium Garden apartment under Jalukbari OP jurisdiction. Acting upon the information, a police team immediately proceeded to the suspected location and intercepted 3 persons, namely Ziarul Haq, Annaz Ali, Rohim Mia. Before commencing the search, 2 independent witnesses, namely so-and-so, were requested to witness the search proceeding. After being informed of the purpose of the search, they voluntarily agreed to act as independent witnesses. On conducting a lawful search of the accused persons and the vehicles found in their possession, the following articles were recovered and seized under a proper seizure memo in the presence of witnesses. 1 Scorpio vehicle bearing registration number so-and-so, 1 Suzuki Baleno so-and-so, 1 Tata Nexon bearing number so-and-so, 1 Alto K10 bearing registration number so-and-so, from the key of which 558 numbers of suspected fake Indian currency notes were recovered and seized. 6 numbers of black colored suspected fake 500 denomination currency notes bearing number so-and-so, so-and-so. My lord, all these vehicles that were parked in that apartment, my lord. And it was not in the name of these petitioners also. From these petitioners, they can only seize 3 mobile phones. They were having that. So basically, the fact is that these 3 persons, they're workers, my lord, and they were called for some construction work by this absconding person, my lord, absconding accused persons, as they are Islam Ali and Sumi Bora. And if your lordship will look at the next phase, at page 17, further, the following mobile phones were recovered from the personal possession of the accused persons. This 1 Vivo mobile phone, 1 Oppo, and 1 Techno. During interrogation, the apprehended accused persons voluntarily disclosed that the seized counterfeit currency notes had been printed and manufactured in room number so-and-so. They further disclosed that the said room had been taken on rent by Islam Ali. That room was also taken by the accused person, my lord, the other absconding accused person, and his wife Sumi Bora, both residents of so-and-so, so-and-so. The accused further stated that Islam Ali and alias Sahil and Sumi Bora were principal conspirators of the counterfeit currency racket, and that all 5 of them were working together as a team in procuring the equipment and raw materials, printing fake Indian currency notes, storing them, transporting them, and circulating the same in the market by other accused persons.
You are who as Hussein?
Ziarul, my lord.
Ziarul.
Ziarul Haq.
My lord, the next point is important. Thereafter, the same police team accompanied by the SCP so-and-so proceeded to the room number so-and-so. Means it is apparent that they were not in that room where the fake currency and the machines were there. They were just in the parking lot of that apartment, my lord. And that vehicle was also parked in that apartment, my lord. On a suspicion, they were arrested, my lord. And they have no link with that counterfeiting of notes, and nothing has been seized. No notes, no fake currency notes has been seized from them, my lord, from their possession. It is from a vehicle, that is Alto K10 vehicle. It is in the dicky. It was there, my lord.
Who is the owner of the vehicle? Thing is there.
They are not the owner of the vehicle.
But the vehicle is in the possession of, at that point of time, my lord, of the accused persons, my lord.
Vehicle cannot be in a inside a room. Vehicle must be somewhere.
Parking lot.
It's in the parking lot. So you have to connect them to it. They were not inside the vehicle.
No.
No.
So how do you connect the vehicle to them?
As per the statement of the accused persons also, my lord, পিছত আৰক্ষী আমাৰ লগত আমাৰ কবলত থকা বাহনসমূহৰ তালাচী লয় আৰু তাত উদ্ধাৰ কৰে।
It's a statement of the accused person.
Yes, my lord. My lord,
it's not
anything recovered from the person.
From their pocket or
Nothing was recovered.
Nothing.
So what talasi loy and recovered? What was that? Just now you read?
আমাৰ কবলত থকা বাহনসমূহৰ my lord.
Oh.
Their position, they're and they may be now my friend has
Whose statement is that?
Zero, this petition.
His own statement. That is not admissible anyway. How many days now?
26.
They
26 days.
My lord, fact is that the main culprits were not there. Islam Ali and Sumi Bora was not there.
So as because
and my lord, they looked to the police party to the room. This three, they were my lord, caught in the my lord, parking lot, and first that car. Subsequently, they were lead to the my lord, that room, and in that room those my lord, printer machine and my lord, other materials were seized. So they have lead to the room. So my lord, they were
there is no proof.
Sumi Bora. Who led?
Yes, Sumi Bora and Innas Ali.
Not Ziarul.
Ziarul, Annas Ali and Rahimia, they were caught in the
parking lot.
And they both, the 3 person lead to the police person to the flat. And in that room, those printing materials and all this were seized.
It is this.
No, which 3 persons?
Other 2, in the same forwarding report, there are 3 persons. He is the number 1, Ziarul, and 2 other persons are the Annas Ali and Rahimia.
My lord, the room is rented by the absconding, both the absconding accused petitioners. So there is no connection of that with this present petitioner, my lord.
And he has stated that they were called for some works. There may be some distributors, also. They are going to distribute those notes, my lord. The investigation is still going on, my lord. Investigation is in progress.
There is might, everything, my lord. But that doesn't mean that, yes.
Where is the proof? They are
exactly, since there is no proof, my lord. So, but the benefit should go to me, my lord.
Still, my lord, investigation is going on, my lord. And how they know, my lord, what is in the room, my lord? They lead the police team to the room, my lord.
As because they are unable to arrest the absconding accused person, that doesn't mean that we have been languishing in jail, my lord.
They are working with the main persons. They are distributing these notes, and they know everything. Because of that, they led the police party to the room.
So nothing has been seized from them. No vehicle, no currency notes.
One may not be a registered owner, my lord, my lord, of that car, my lord.
But you should have found out the registered owner by now.
Exactly, my lord.
What is the difficulty in that?
My lord, the registered owner of that.
Then investigated him.
Driving license, this.
That would have been even better if he implicated you. That it was vehicle was rented out to them. Then also you would have had a better case.
Yes.
My lord, in
They
that
could
case,
have done that.
In that case, my
But
lord, I have to talk to the, I will once maybe fix tomorrow, my lord.
why, my lord? CD has come. CD has come, my lord.
2,79,000 total amount, my lord.
What more remains, my lord? And it is also not proved that that 2 lakhs were, whether that was fake currency or that original currency, that was also not proved. Whether is there any
It was
report?
You said for FSL, my lord. It is FSL report will not come in one day, my lord. Investigation is still going on. Charge sheet not submitted.
So he, along with the two other arrested accused, led the police to that room
In
where the
other materials, printer machines and other ink, other materials, cutting papers, all this were seized. Cutting papers in the size of denomination of 500 rupees and all this. How they know, my lord? If they are came to some work, my lord.
My lord, I know the address. Definitely I know, because I know that absconding accused person, I'm a worker under him. So he called me for some construction work, my lord.
I have got
so I know his address. That's why I have appeared in that flat, my lord.
Palki Siddhi, my lord, I have not.
And I do not know what was. I do not know what was
I'm
inside.
not getting the check the all the papers, my lord. I need some time, my lord. Maybe fix on tomorrow, my lord.
All right. Third learned counsel for the petitioner. Learned additional PP at length. However, additional PP prays for some time to go through the CD, which is bulky. List the matter. Friday.
Friday, my lord. That's all.
Cancellation.
Yes.
62, my lord. This bail application has been filed by the state court cancellation of bail. Well, but that order is at page, my lord, 28.
Huh?
Page 28, my lord.
Nayan Jyoti Das.
Yes, ma'am. Regarding, my lord, only on the ground that, my lord, no notice was issued to the victim. That order was passed on 16/10/25 later on, my lord. In record also before that, what happened, my lord, that I have not order of the trial court, my lord. In fact, my lord, only in presence of the, my lord, State counsel on behalf of the accused, my lord. At present, trial is going on. At the trial, my lord, I have seen the record that accused appeared, my lord. And my lord, order is illegal because, my lord, this is violation of our division bench order in Deepak Nayak versus State of Assam, my lord.
Please, your lordship.
They have also filed one objection, my lord, only on that ground. And my lord, next on that day, my lord, PP was also not there. I have not seen in the order dated that regarding presence of.
This is section 6.
POCSO Act.
Yes.
Charges have been framed under section 4, my lord.
Regarding materials, my lord, medical report, everything, lots of
Yes,
documents.
released before
present,
such
my lord,
charges
not-
were framed.
And he appeared, my lord, during trial. Well, I have seen the record. my lord.
Regularly appearing, my lord.
He is appearing in the before that. I would like to leave it to lordship, my lord. In fact, my lord, prima facie, it seems that, my lord, the record also I have not found anything. The record also I have not found anything that, my lord, notice was victim. The order was passed on 16/10/25 later on. Before that, my lord, I tried to find out if there is any order, my lord, that also I have not found in the record.
Lordship, so far the procedure of filing of the bail application in POCSO case is concerned, my lord. At the time of filing of the submission of the bail.
Lordship, may kindly see FIR at page 14. The FIR is itself very clear that after 24 hours of arrest, taken into custody, and they were produced. May I read the FIR, Lordship? This is to inform you that your Lordship will find the reference Lambding PS GD number 015 dated 23/8/2025. This is to inform you that based on specific information received on dated 23/8/2025 at about 4:30 p.m. by reliable source that regarding dealing of suspected NDPS items which were coming from Silchar side towards Lambding. Accordingly, Deputy SP so-and-so, Co-District SP is been informed by OC Lambding PS and made a ZD entry while Lambding PS ZD entry number 015 dated 23/8/2025. And SI Ankur Kakoti formed a team for do the needful against the suspects NDPS peddlers, and accordingly SI Ankur Kakoti along with UPC Ritu Bora and 2 numbers of APV and staff of Lambding PS proceeded with the operation on government vehicle hide registration number so-and-so to do necessary legal action against the suspect along with NDPS toolkit and drug detection kit. After arrival at Itapata Sariali NH 27 SI so-and-so along with UBC so-and-so and 2 numbers of APV and staff put special Naka at Itapata Sariali, waited for some time for source update. In the meantime, while I left PS and arrived at Itapata Sariali and joined the team in special Naka placed at NH 27. After some time, Deputy SP so-and-so, Co-District SP at about 7:57 also arrived at Itapata and joined for the special Naka checking. After some time of waiting, our source showed us the drug peddlers who were suspected to be carrying NDPS articles on 2 different scooters, and accordingly the suspects, namely T.H. Surasingha, that is the petitioner before Lordship, and others who were stopped and requested to cooperate with the police. At this juncture, the suspects seemed to be frightened and shaken. So by 8:30, they were taken into custody and their vehicles were searched.
Where is that 8:30?
No, that I'm assuming that because on 7th at 7:57 p.m. the entire police team reached the place of occurrence, and after some time the source showed them that regarding the present petition and others. And that is in fact, the seizure was made on 23/8/2025 at 8:28 p.m. I have submitted the certified copy of the seizure. At the top of the page of the seizure, your lordship will find at 8:28 p.m. the seizure was made.
Yes, then
Then your
production.
lordship will find page number 17. The production order passed by the learned SDJM Hujai. It mentioned the date 25/8/2025. So they were produced after 37.5 hours of their taking into custody. In fact, four accused persons were arrested. 2 of them were discharged. That discharge order I have annexed also. And the other
Contraband recovered
from them. And the other one was also released on bail on the ground that the production was not made within 24 hours.
Where is that? Who was released?
Coordinate bench of this honorable court granted bail on the ground that the production was made after 24 hours of arrest.
This is who? Kiran Sinha.
Kiran Sinha.
And you are?
P.H. Suraj Sinha.
Both of you were apprehended together.
Yes.
So what remains?
Otherwise, notices.
Huh?
Served.
In fact, there is an
It
observation.
is served under section 47, 48 complied.
That
These are
observation.
findings of fact by a coordinate bench. We can't depart from that.
Yes. Regarding 48 notice also, there is an observation that was not served.
This memo's concerned lordship, date of arrest is shown as 08/2025.
Yes, the usual thing done by the police.
On record, it is 24.
At 1
More than 25 lordship.
at 1
And it was
a.m.
produced on the next day lordship before the magistrate, and I.
Rest of the things we may not, but we are only on this at this point.
That's it.
48 and all, I don't know in your case what has happened. We haven't.
That's it.
The commercial quantity lordship.
Commercial quantity and all those things don't make any difference.
It is recovered from their conscious possession.
All the more reason why you should have produced them within time.
Paragraph section 37.
You completed everything, seizure and everything at 8:30 p.m. in the evening. Why couldn't you produce him? Next day, all day was there. 24th whole day was there. You could have produced him.
Saturday lordship.
So, why are our magistrates sitting
On Sunday.
even on Sunday instead of going for a picnic?
Lordship otherwise.
All right, we'll pass on this.
Right, Lordship. Lordship, may I humbly submit that the only thing is that if your Lordship puts up a condition that he will not leave the territorial jurisdiction of the court, then there will be difficulty because he is a resident of Tripura. So he will regularly appear before a trial court. Yes.
Lordship, not paid because
Only the jurisdictional part, Lordship.
hailing from other state, Lordship, Tripura.
It will see.
The other accused person who was arrested with him, he is cooperating with the trial. So he will also cooperate with the trial, Lordship. Much obliged, Lordship.
Its training observation must be there, Lordship.
My lord, in respect of item number 25, mandatory period for filing search sheet is 90 days. And regarding CD, my lord, CD is actually available. Today, one other matter is listed in court number 22.
Which section? Which section is 90 days?
148, my lord. 148.
148 BNS?
PNS, yes.
No, this is also not 90 days.
But imprisonment, punishment for imprisonment of for life is also there, man.
Life may be there,
There is condition, my
but minimum is not 10.
Well, if my lord, maximum period is, my lord, extend up to imprisonment for life, my lord.
basing on the grounds and facts. Help your lordship.
Go through Rakesh Pal. Minimum sentence must be 10 years. It says it's up to 10 years.
My lord.
Anyway, what 140? How is 148 attracted here?
Because, my lord, he is involved in, my lord, illegally transporting, my lord, foreign nationals to India, my lord.
But on suspicious grounds, my lord, only arrested. My lord, kindly may peruse this page 15, only single line, my lord, may.
So even if you go through the grounds of arrest, the ingredients of 148 is not there. Posing a threat to national security and conspiring to overthrow the government of India, that is a different thing.
CD is, my lord, CD will reveal, my lord, otherwise what are the other materials? He is in court number 22, my lord, in respect of one other item listed as item number 49 today, my lord.
My lord.
Is waging war against the government of India.
My lord.
And where you are talking about pushing somebody across the border.
Where is fencing and border security force is there, but the on suspicious ground, the accused number one.
No, we are not on all that the moment. I heard learned counsel for the petitioner and learned additional PP. This is an application under so it appears that the petitioners were arrested on
your lordship
16/5.
17/5/2026.
17/5/2026, and since then they have spent 65 days.
My lord.
9 bars. None of the cases under which the present FIR has been registered, none of the offense sections under which the present case is registered relate to an offense where the minimum punishment provided is imprisonment for 10 years or above. Therefore, in view of the decision of the Honorable Apex Court in Rakesh Pal versus State of Assam, the statutory period of detention regarded as 60 days. The instructions received on an additional PP submits that charge sheet has not been submitted. Therefore, the petitioners are entitled to default bail. Accordingly, it is directed that the petitioners so and so shall be released on bail of rupees 50,000 each with securities of like amount to the satisfaction of the who? CJM South Salmara Mankasar. But provided that the petitioners shall cooperate with the investigation and the trial if one commences. Petition stands disposed of accordingly.
Highly obliged, your lordship.
May it please your lordship. I'm for 28 lordship. Lordship, in this case, this petitioner lordship in jail custody for 10 days. Lordship case was registered under 14 and 16 of the Assam Game and Betting Act. Lordship. FIR lordship will find on page 13. Lordship. No instrument was recovered. Lordship, only 10. FIR lordship will find on page 13. Lordship. These 4 persons actually they are the fish vendor lordship. They are on the in the evening time lordship. They are in the market lordship and talking about their business transaction lordship. In the meantime, police has come and said lordship, you are playing gambling lordship. The amount has been seized and 10 rupees coin. They say it is used for gambling purpose lordship. Now,
Cash is also there.
Cash is their own money lordship. It is not from the gambling lordship. They are not playing gambling lordship. And even lordship 35(3) notice was not issued because the section 14 and 16 lordship minimum sentence is 6 months and maximum up to 3 years lordship. Then 35(3) notice was not issued to this petitioner lordship. In the rejection order lordship that is reflected on page 22 lordship.
In this case, my lord, one other item listed, item number 28, case diary is available. My lord.
Since lordship, the money already been seized lordship, keeping them in jail lordship. What investigation will do lordship, recover further unearth anything lordship by keeping this person in jail lordship. They said lordship.
How many days?
10 days today lordship.
Okay. For the petitioner and learning. Additional PP, this is an app. So and so. The allegation in the FIR is that upon receiving information that some people were gambling near the market in Khameri under Nogorbera PS, the raid was conducted and the petitioners were apprehended while gambling, and a 10 rupee coin and cash amount of rupees 34,840 was recovered from them. Parallel counsel for the petitioner submits that petitioners are fishermen were discussing matters among themselves, and the money recovered was their own money. From the sale proceeds of fish or what?
Yes, Lordship, it's dealing with the fish item, Lordship.
Initially, 4 persons were arrested on spot. After this.
How many petitioners?
4 petitioner here.
Here in this petition, item number, this unlisted matter, my lord, there are 4.
Yeah, going with this listed matter first.
Or 24, yes, only two persons.
4%. In 28, 4%. 20
Submitted on behalf of the petitioner that further submitted that the cash amount and coin has been seized and there remains no necessity of keeping the petitioners in custody any further, as they have already spent 10 days behind bars. The CD available submits learned PP. Having regard to the nature of the allegations and the period of detention, therefore bail is allowed. 20,000 one security each.
JMFC, Boko. Highly obliged.
Well, how were these two arrested?
My lord, in 28, they were in jail since 13/7/26.
Yes, my lord. And I am for
No, the FIR says these 4 people were found.
Yes,
then
my
how
lord.
come these
They
2
were
are
arrested subsequently, my lord, merely on suspicion. Nothing has been recovered
That
from
unlisted matter, my lord, those accused persons were arrested subsequently. My lord. In
From,
item number 28, those were, my lord, caught red-handed by the policeman along with those. Initially, though, these 4 persons were arrested. My lord.
একটু দেৰি কৰি দিব আগৰ দৰে একেই হ'ব পিটিশনাৰ্ছৰ জাগাত some accused persons were caught apprehended বুলি subsequently on the basis of statements of the arrested persons the present petitioners were arrested এইখিনি একেই হ'ব deeply up.
Item 52. Plus.
December. Yes, what is this about?
Lordship, I am the respondent number 2 in the criminal petition and the petitioner in the interlocutory application 1308 of 2025, Lordship.
May it please, Your Lordship. The matter was earlier listed before a coordinate bench. I'm for the petitioner. However, the matter, the coordinate bench, His Lordship was pleased to recuse him from hearing the matter and directed that the case be listed before any other bench. So I'm on behalf of the council for the conducting council, my lord. I'm seeking another time for hearing, my lord.
Lordship, I had informed them that the matter is going to appear today. After my lords have agreed to the upgradation, I even informed them of the upgradation also. The petitioner is a persona non grata, Lordship. He has no right of audience. Let me be heard, and then my lord, if think fits that he is worthy of being heard, Lord may hear him. But if they are playing fraud on this court by suppressing facts, how can they be allowed to present their case? They are absolute persona non grata, Lordship. They have been playing fraud throughout, Lordship.
Yes, let us see what is it about.
Lordship, please let me allow to bring the facts before this case, of this case.
Yes,
This is the 27th time this criminal petition has come up for hearing. Before this, Lordship, Honorable Justice Pathak reserved it for judgment, but it did not come up for some reason, and it came up for fresh hearing in 2025. And lastly, Honorable Justice Majumdar reserved it for verdict on 21/4, but on the last occasion, he directed it to be placed before any other bench. Let that as it may be. I requested the registry to list it because it has not been able to reach its final destination.
and the matter is very serious because fraud has been played on this court. Now, Lordship, when a reasonable notice has been served that the matter will be called for upgradation, when it is upgraded, they are informed. If they don't have time, why did they take the brief? The court cannot wait for him forever. There is an ad interim injunction, Lordship, which needs to be vacated. Now, Lordship, let me present my case.
Yes.
The petitioner in criminal petition 558 of 24 obtained bail from this honorable court on the strength of forged fraudulent documents. I brought it to the notice of the court through an affidavit, as well as I filed a FIR with Latasil police station. The affidavit was ignored. They were granted absolute bail. The FIR has culminated into a charge sheet, cognizance taken. Now, after summons being issued, they have come to this court. Now, Lordship, this is a twofold fraud on this court. Firstly, the fraud was played in the anticipatory bail. Now, sir, the fraud is being played in the criminal petition. My Lord may kindly come to page 13 of the petition, Lordship, para 5.15.
Yes.
Lordship, the last three lines of para 5.15. May I read, Lordship?
Yes.
It is pertinent to state that the petitioner was never summoned or interrogated by the police in connection with the said case during the investigation. Now, Lordship, this is the case lodged in Latasil PS for fraud on this court, forgery, where he has been charge sheeted. Now, Lordship may kindly come to the charge sheet, which is on page, which is annexure 15, page 80, Lordship, of his petition.
Page?
Page 80, Lordship. Annexure 15.
Yes.
Lordship, page 80A. Point number Roman 22, Lordship. The first para, Lordship.
Yes.
Status of the accused not arrested on compliance of notice under 41A. Now, Lordship, when the petitioner says I was never summoned, the charge sheet says he appeared under 41A, which is a notice. Now, Lordship, when the matter was being heard, this court directed the petitioner to bring it on record that whether you were called for investigation to join it or not. Now, Lordship may kindly see supplementary affidavit filed at the directions of this court.
Page?
Lordship, the affidavit is, I think it's page 87, Lordship. In criminal petition 558 of 24, Lordship. Para 4, Lordship.
Additional affidavit.
There is only one affidavit, Lordship. I apologize. The affidavit is on page 87, Lordship.
Is it on record?
Lordship, it's on record.
Yes, page?
Page 87, Lordship, para 4. The fourth line, Lordship. The deponent humbly submits that he was summoned by the concerned police on one occasion only. Now, Lordship, he takes a 180-degree turn from his petition. He said, I was never summoned. He lamented, he shed crocodile tears. He got an ad interim injunction on the trial court proceedings. And when the court asked him whether you are really never summoned, now he says, I was summoned once. Why, sir? Now, Lordship, the best part of this case is that he has attached a document which is a fraudulent document, which forms the basis of my FIR with Latasil police station. And again, he has annexed the same here as annexure 2 on page 25 of this criminal petition, Lordship.
Yes, agreement.
Lordship, this is a forged document, Lordship, a false document, a fraudulent document. The signature on page 26 stating of Manish Agarwal is a forged document, Lordship. It's not my signature. Now, Lordship, a very interesting case before my lords. If my lords can kindly take up the affidavit filed by them again, because the case has been running long and I will take very little time to bring the entire case before my lords. Lordship may kindly come to page 87.
Yes.
This honorable court asked him that where is the document, because you have attached a certified true copy. And in the affidavit to this particular criminal petition, Lordship, he has stated that all the annexures are true and correct copies of the respective originals. Lordship may kindly come to the affidavit filed by them with the petition, which is on page 23, Lordship. Para 3.
Yes.
Lordship, that the annexures annexed to the petition are true and correct copies of the respective originals. Now, Lordship, this, I am not a student of law. I have very little knowledge. But when you say it is a true and correct copy of the respective original, the original must be in front of you. Otherwise, how can you make a true and correct copy? Now, Lordship, please come to page 87 of the affidavit, para 3.
Yes.
May I read, Lordship?
Yes, yes.
That with regard to the first query concerning the location of the original agreement, the deponent humbly submits that upon the execution of the agreement, the original copy thereof was written by the private respondent number 2, that is me, and the deponent written only a photocopy of the agreement. Accordingly, the original agreement is in all likelihood in the custody and possession of the private respondent number 2. Lordship, this fraudulent document is dated 20th of January 2017. And this petition is filed in the year 2024. If I took away the original in 2017, how do you come to prepare true and correct copies of the originals in 2024, Lordship? Now, Lordship, this fraud has to be nipped in the bud. My lords can kindly come to annexure 4 of this criminal petition, which is page 32.
What is the date of the agreement you said?
According to him, it's 20th of January 2017. The fraudulent forged document, Lordship.
Then what was your submission?
Lordship, the agreement is a fraudulent one. It's
No,
not mine.
no. After that, after you mentioned the date of the document, his contention is that you retained it.
He says that after signing it, that is on 2017, I took it away. If that be so, Lordship, if I took it away, how can you prepare a true and correct certified copy of the respective original in 2024? The original is not with you. You cannot prepare
This was filed in 24.
copy. Yes, Lordship. This petition is filed in 2024. It is next to impossible against the principles of natural justice to prepare a copy whose original is not with you. They have been playing with this honorable constitutional court like anything, Lordship. They have made it a laboratory to experiment with lies. With the humblest of submissions, Lordship. Now, my lords can kindly come to annexure 4 of this criminal petition, which is on page 32, Lordship. It is a document from a police station, Lordship. And it is also not a certified copy. Now, Lordship, I do not understand how he gets holds of documents signed by police officers, gathers the courage to annex it with the petitions, which are not certified copies. How do he get hold of this? Lordship may kindly come to para 5.16 of his petition. He says, when the charge sheet was laid and summons were issued, I never received any summons from this honorable court, the trial court. Now, Lordship, a classic case of fraud is here. My lords can kindly come to annexure 15, which is the charge sheet of the case.
Section 15 page?
Page is, Lordship, 80.
Yes.
Lordship, this is also not a certified copy obtained from the court. If the petitioner was never summoned by this trial court, how can he lay hands on an uncertified copy of the charge sheet? This was also asked to be put on record. Lordship, he has placed the entire burden on the court staff. They say that I applied for the orders and they gave me gratis out of courtesy without applying the certified copy. This is in his affidavit, Lordship. If my lords can kindly come to page 88 of his Lordship affidavit.
Page
88, Lordship. They say we applied, but they omitted to certify it. Now, Lordship, it is a classic case. If you are given the charge sheet, why the FSL report was suppressed? Is it not tampering with evidences punishable under 466 IPC? Why do you have to suppress the FSL if you are so clean? Now, my lords, I have placed two documents through the court master via email a little while ago. One is an order of this coordinate bench of this honorable court, and one is a report submitted by DCP Central. May my lords have it. Lordship, first the order of this Honorable High Court by the coordinate bench. There came a case when a person applied for an anticipatory bail suppressing parts of the complaint. The court treated it as a offense under 466 and Registrar Judicial was directed to conduct an inquiry. The same grounds hold here, Lordship. He has suppressed the FSL and he has a uncertified copy of the charge sheet, which is never possible, Lordship. In my 8 years of this legal journey, I have never come across that I apply for a certified copy and I get an uncertified copy. Even my lords would not have come across such. Secondly, Lordship, I have presented one report from DCP Central, which was submitted to me. Now, Lordship, the agreement attached as annexure 2 of this particular petition on page 25 and 26 is a fraudulent document. I go to the police to register a case. They say, no. We have already given him one charge sheet under the anticipatory bail fraud. So why do you want to prosecute him again? Now he has the liberty to use the documents ever and ever again throughout his life. How can it be, Lordship? This petition is a different cause of action. Anticipatory bail was a different cause of action. Annexure 2 is not a continuation of the anticipatory bail petition. It's a standalone document, Lordship.
Yes.
Now, Lordship, the IO who investigated the case and submitted the charge sheet, the trial court SDGM 2 has directed a FIR against him also for being hand in gloves with the petitioner, conducting intentional, deliberate, willful, perfunctory investigation. Now, Lordship, I want to present a simple judgment. Lordship must be aware. 2007 SCC 449 Prestige Lights. When you suppress frauds from this court, you commit fraud on this court, which is the utmost contempt. And when you are under contempt, you cannot be heard. You have to be thrown out from the proceedings. And I pray for the same. They have no right of audience, Lordship.
So the trial is underway before the SDJM.
Lordship, there is an ad interim stay which has died a natural death. But since the order vacated is not there, the trial court is not proceeding since the last 2.5 years, Lordship. And my prayer for further investigation is also stayed there, Lordship. The prayer in my IA, Lordship, is to vacate the interim stay which has already died a natural death. If my lords take up the IA 1308, Lordship. Let him produce the original document, Lordship. My lords can kindly take up my IA 1308, Lordship.
Yes.
They obtained an ad interim stay without us being heard, Lordship. And thereafter, it has never been continued. My lord can kindly come to page 9 of my IA, Lordship, para 7.
This IA is for what? Vacating the order?
Vacating the order, dismissal of the criminal petition, initiation of proceedings under 340 CRPC read with 195 IPC and other like prayers. But at this hand, Lordship, my first prayer is to vacate the stay because it's an ad interim stay, died a natural death, it's a deadwood. And I pray it so that further investigation can be done to bring the questioned document. The IO of the case is under FIR and SCP rank officer, Lordship. It's a case of perjury. He stated false in his criminal petition that he was never summoned by the police. Now he has not even expressed a regret, remorse, or repentance. He has not expressed unconditional apology that I made a mistake in my petition. How can he be let off like this, Lordship? And Lordship, I pray for an inquiry from Registrar Judicial as to how he laid hands on an uncertified copy, whether he applied for the same, and whether an FSL was not provided to him, because Section 466 IPC is truly attracted in the case.
Yes, that is all.
Lordship.
Yes.
My lord, I respectfully pray on behalf of the conducting counsel that he may be allowed to address this honorable court, my lord. As today, due to some personal difficulty, he is unable to appear. And the matter was already heard, my lord, by the coordinate bench. So he may be allowed, my lord.
This is for fresh hearing after recusal of the court. So it has to start from beginning again with all the documents and records before this court. And since you are under contempt, you lose your right of audience to the best of my knowledge. You have no right of audience. Lordship, a stay which prevents further investigation needs to be looked up by my lords. The order of stay is June 2024, Lordship. May find it from the criminal petition, the sheet order sheets, Lordship.
See, if we are taking up the IA, that is one thing, and if we are taking up the main criminal petition, that's another thing. There he is the petitioner.
Lordship, may kindly take up my IL, Lordship.
Okay, we have heard you on your IA, so we are inclined to hear him also as to what he has to say. So we are going to fix a date for his reply next week.
Yes, my lord, can it be fixed on 13th of September, my lord?
Lordship, he has a habit of
Nothing
keeping it for weeks along. He has
My
no
lord,
right
because
of audience at all.
I will be traveling from Itanagar
You
to
may
appear
travel, you
before
can recuse yourself,
before
sir.
my
You
lord, my
cannot
lord.
make this court a sufferer because of your ill deeds. You are
We
under
are, we
contempt.
are willing to accommodate you for a limited period, but don't make obnoxious submissions like September, October. All right.
Lordship,
Okay, my
it may
lord.
be
My lord,
tomorrow. We
any
have
date,
come
my
to
lord.
this
We are
court.
hearing you on any day on the next week. Without that, we'll pass orders. If any inconvenience is there, you make alternative arrangements.
Okay, my lord. Then next week, my lord.
Lordship,
Next.
I pray it on Friday at 2, Lordship. It is a very serious case of perjury, Lordship. Even the counsel who has
Yes, give your
certified true
date.
copies needs
Yes,
to
we
be
have
brought.
heard you. We are listening to him now. Yes, give your
Lordship.
date.
My lord, on next week, my lord, any
Yes.
date I will be appearing before this honorable court.
Yes, yes, next Thursday.
Lordship, may kindly take it
Thursday.
on Monday, Lordship.
Right, 30th July. Heard petition in IA. Okay, 1308 heard the petitioner in person in the IA. Learned counsel for respondent seeks some accommodation on account of personal difficulty of conducting counsel. Hence, lays the matter again on 30th of July. For reply of the respondent in this IA.
Lordship, may it be at 2 p.m., Lordship, on 30th?
Highly obliged, my lord.
Don't fix the time right now. On that day, we'll see.
Lordship, the reason is that I am always at the last of the list, Lordship. That is the humble prayer, Lordship.
We have accommodated you today.
I am obliged, Lordship. I am obliged.
Hello.
I am
Yes, sir.
obliged.
Hello.
Highly obliged.
Sorry, my lord, CD not received. my lord.
Lordship, CD, I believe.
CD not received.
Interim is there.
Yes, Lordship. 9/1/26.
They did not receive. List again on. So interim continue.
5th of August, my lord.
Lordship, can it be a longer day?
8th of August. 8th of August.
I'm obliged.
May I please, Lordship?
31 also, my lord. Interim is there, CD not yet received.
Same order.
From Kasar, 8th of August, my lord. Shasthi submitted. Close. 32.
Lordship,
Shasthi submitted.
Yes, search it.
Proceeded, Lordship, and interim was there, Lordship, and we appeared before the IO, and our statement already been recorded, Lordship.
What do you want to do now?
Lordship, also I have received a summon from the learned special judge Poksu, Lakhimpur, Lordship, and date is fixed on, Lordship,
10th of August, Lordship. I'll appear, Lordship. Interim may be absolute.
Interim order is there.
Interim order perhaps because of his exam, appear in the examination, interim was granted. Anyway, he's received the summons, he will appear.
Lord learned counsel for the petitioner and learned additional PP. It stated that charge sheet has submitted in the case by CS number
1/2026 dated 16/6/26.
Learned counsel for the petitioner submits that he has already received notice from the trial court, summons from the learned trial court, and intends to a petitioner intends to appear pursuant to the summons before the learned trial court. This petition is disposed of with the direction that the petitioner shall appear before the learned trial court on the next date fixed. Till that date, the interim protection granted by this court by order dated 15/5/26 stands extended. Petition stands disposed of accordingly.
Right.
Look, in this case, CD was called for, my lord. On last occasion, CD was there, but FSL was not there.
My lord, CD returned back for updation, my lord, updated CD with FSL not received.
It's pending since March, my lord.
Is the matter about?
NDPS, my lord,
NDPS, my lord.
intermediate quantity.
Intermediate quantity. No, AB, intercity bill.
AB, my lord.
AB.
NDPS commercial, intermediate quantity.
The FSL report required for that.
In my file, my lord, it is written updated CD along with updated CD, my lord.
What is your name?
His name is
Makades.
Makades.
No, who is the Makades?
Makades is the petitioner, my lord.
This is anticipatory bill, my lord.
No, it was recovered from your house.
My lord, house premise, my lord.
Eh? From under your bed.
He was not present at that moment, my lord.
Clock of the house was broken.
Yes, okay.
Anyway, we have to see the CD.
Yes,
whether or not. is Updated CD not received. So reminder to produce the CD along with FSL report if available. Just again on
12th of August, 12.
In the morning, I wanted an accommodation in this case because of the fact lordship. A notice has been issued by the IO to the petitioner on 19th lordship. Here is a copy. My dear. And the copy.
This case of
35(3) notice has been issued on 19th and in fact today also date fixed. My instruction that he would be appearing today and as per Arnesh Kumar lordship, punishment which are up to 7 years.
case of
On notice also it can be dispensed with. So lordship, my instruction, he is appearing today. So updated. A call for along with his statement lordship.
will never.
On 19th only this has been issued. Lordship may see the date written there, 19 and today's date.
So you are appearing today.
Yes, that is my instruction, Lordship.
There is no interim order.
No,
He is not the.
and I did not
This is a
search.
case of my lord vehicle theft. My lord, he is involved in many other cases.
The CD is here.
CD is available. My lord. CD is.
He is appearing there.
Regarding a 35(3) notice, my lord, earlier also, my lord, I have one notice of 35(3), my lord, issued to him, my lord. Till now, he has not, that today, my lord, matter is listed now, my lord.
That written is there.
There is no possibility that
He has received
he
it
will
Lordship,
appear.
on 19. And today's date is fixed, Lordship. And otherwise also, Lordship may close that no, because once this his attendance is dispensed with, then there will be no cause of apprehension, Lordship.
Is involved in, my lord, Nunmati
Yeah,
PS case.
brief is not with me, Lordship. That is why I.
Attendance dispensed with.
Lordship, brief is not with me. That is why I sought in the morning only. I mentioned I sought for time in this matter. But Lordship say that they did come serially, Lordship. Item 34. I mentioned in the morning.
Because we are making some submissions which required verification.
Yes, Lordship may. That is why updated CD may call for even day after tomorrow, 24th may be fixed.
Against the present accused person, Nunmati PS case number 2126.
Sir, Lordship, we have added.
Third learned counsel for the petitioner, it is submitted that a notice has been issued to the petitioner asking him to appear today, that is 22/07/26, before the IO. Copy of the notice has been furnished.
And
The
you know
court
this.
permitted that the petitioner shall appear before the IO today, as per instructions received. Hence, CD is available in the court with the learned additional PP. Hence, list the matter again on when, Monday?
Yes, Monday.
PP may obtain instructions from the IO as to whether the petitioner has appeared pursuant to the notice.
Obliged, Lordship. Deep dive.
May please, Lordship. My lord, CD was called, Lordship, in this case.
35, my lord, case diary not received.
My lord, this is the 5th occasion matter is listed for CD.
PD and PM report, my lord.
Yes, Lordship. My lord, there are 2 ladies, Lordship. The
Yes,
main
sir.
accused were arrested, and the now petitioners here is the sister, mother, and brother-in-law of the main accused, Lordship. They have no involvement. In fact, the victim and the petitioner number, both of them are drugs addicted, Lordship. due to overdose of, that might be due to overdose of drugs, the victim might fall in the river. But here petitioners are the family members also. And the 62 years old lady, the mother of the main accused person, is here as petitioner lordship. Lordship kindly consider this is for the 5th occasion fixed for CD lordship. There may be provided.
How many petitioners?
Three
Three.
petitioners lordship. Petitioner number 1 is the mother, 2 is the sister, and 3 is the brother-in-law of the petitioner accused number 1, who is the main accused. And the petitioner number 2, who is married to a different place, 30 kilometers away. Both petition number 2 and 3 reside here, lordship.
Heard learned counsel for the petition and learned additional PP. Case diary as called for has not been received. So, by order dated 7/26. One further opportunity was granted to produce the case diary, but has still not been produced for the 4th time today. Considering the above, it is directed that in the event of their arrest, the petitioner shall be released on interim bail of rupees 50,000 with a surety each for like amount. The satisfaction of the arresting. Further directed that the petitioner shall appear before the IO a period of 10 days from today. The
Deep
purpose of
obliged.
interrogation list again on.
Deeply obliged.
May it please your lordship. Lordship, in this case, section 4 of POXO Act is involved, my lord. Therefore, notice was issued to the informant.
The notice
And
already,
as-
service already
Yes.
completed, my lord. Report already sent to the registry, my lord.
Yes. As no one has appeared for the informant, amicus may be appointed, my lord, and fix the case on day after tomorrow, if possible, my lord.
Additional PP submission instructions received at notice on respondent number 2 is complete, but none appears to represent her accordingly. And so is appointed as amicus to the respondent number 2. Fully appointed amicus. CD is here.
CD is available.
here.
CD is available, hence list the matter again on.
On 20th Tuesday, my lord. And my lord, short sheet submitted in this case.
Lordship, we have not yet received summons, so either the bail may be made absolute or we may be allowed to be on interim till we receive summons from the court.
No, we can't give a blanket order that till receipt of summons. We don't know when that will be.
Absolutely. We will appear whenever we are summoned before the court. We have complied.
Make it absolute without having seeing the case diary or anything. Because there are allegations of 109 also. Another call for the TCR or we can
TCR.
give you limited protection. Till appearance.
Till appearance for
Fix a date. Next date fixed. Find it out. What is the next date fixed? That sheet has CS number. Give the number.
CS number 127/26 dated 35/26.
Submitted by learned counsel for the petitioner that shall appear before the court below. Hearing protection may be extended till then. This application is disposed of direction that the petitioner shall appear before the court below on the next date fixed. The said case. And till then, the interim order of interim protection dated 26/5/26 hence extended. Then till the next date in the case.
Okay.
Here is also charge sheet submitted, my lord.
Yes.
Your Lordship, we have appeared before the IO, Your Lordship, and we are on interim, Your Lordship. I humbly pray that the matter kindly be proceeded with in accordance with law.
What do you want now? To appear before the IO?
Yes, Your
But before the court, charge sheet has been submitted. Apply for regular bail.
Yes, Your Lordship.
Same order then. Find out the next date fixed and appear there.
Yes, Your Lordship.
Charge sheet number 151/26 dated 25/6. May it please your lordship. This is an application for pre-arrest bail in connection with Bongaigaon GRPS case number 28/26. Lordship, the sections invoked are section 123, 305, 3 subsection 5 of BNS 2020. 123 pertains to causing hurt by means of poison with an intent to commit offense. 305 pertains to theft in a dwelling house or means of transportation or place of worship, and 3 subsection 5 is common intent. Firstly, I would like to read the FIR for your lordship. I read your lordship. FIR is at page 17, your lordships. Page 17, your lordships.
Yes.
May I read the FIR?
Yes.
On 24/3/2026, received a 0 FIR from the complainant so and so, resident of so and so, The complainant lodged a written complaint at Silchar GRP OP under Badarpur GRPS to the effect that on 9/3/26, complainant traveled by train number 13175, berth number so and so, from Sialda to Silchar, white PNR number so and so. The said train departed from Sialda at about 6:50 a.m. of 9/3/26. After departure of the train from Sialda at about 7:30 hours, the co-passengers from seat number so and so requested complainant for exchange the berth from berth number 64 to 62. Initially, the complainant denied, but after repeated requests, he accepted and changed his accommodation from berth number 64 to 62. During the journey period, they had interaction in the train, and about 23 hours, they offered Kit Kat chocolate to the complainant.
So you are the buyer of the stolen articles?
Yes. It has been alleged only in the statement of the prime accused, only on the disclosure of the prime accused, and that is not admissible at this stage, Your Lordships. As held by the Supreme Court also in P. Krishna Mohan Reddy versus the state of Andhra Pradesh.
How do you know? Have you seen the CD? When
Statement of the prime accused is not admissible at this stage, Your Lordship. My house and my shop premises has been thoroughly searched, and no incriminating materials have been found till date. I am apprehending arrest. At this stage, my arrest is not necessary, Your Lordship.
yes, PP.
My lord, here we have received a case, my lord, from the statement of the two accused persons, my lord, who were arrested, my lord, and they have, my lord, eaten the Kit Kat chocolate, my lord. Thereafter, as per lead by the co-accused, my lord, the house of the, my lord, present petition also searched, my lord. In their statement, it revealed that it was given to the, my lord, present petitioner, my lord. Earlier also, they have given to some articles, stolen articles to the present petitioner, my lord. And CDA also reveals well, during the period, my lord, there is a contract with the present petitioner, my lord. Accused person who's contract with the present petitioner, my lord. And sufficient materials are there, my lord, against the present petition. And that the custodial interrogation is required, my lord, through my lord, recovery of the said articles, my lord. And from the statement also, it reveals that earlier also he is also known about that it was the stolen property, my lord. That statement are here. What is for earlier occasion also he has purchased from the arrested accused persons. Here reveals matter there is a direct contact with the matter. From the statement also reveals that they have received 1,90,000 from the present petitioner, my lord, and divided it to between them.
What is there in the CDR?
CDR, my lord. CDR also says that, my lord, there is a contract with the, my lord, the accused person, my lord.
Sir, these are just statements of the accused.
I have flagged my lord CDR in them. And they also led to the house of the, my lord, present petitioner, my lord, but he was found absent, my lord. The same day, my lord, there is a
Leading them to the house by itself will not work unless something is recovered.
Nothing has been
Only
recovered.
then it would become admissible under 27.
But
if nothing, no leading to discovery, then it remains inadmissible.
he has fled away, my lord, and categorically stated by the earlier also he has received the stolen property, my lord.
Materials are there on record.
There's a record,
Lordships.
my lord, from the statement.
These are only the statements of the accused on the disclosure.
For the
statement.
investigation purpose, they had led to the house of
He's
the
trying to divert the matter, Your Lordship.
led to the house of the
And at this stage, Your Lordships, this is not admissible. That is my humble submission.
But learned counsel for the petitioner and additional PP. There is an application under so and so. The allegations as reflected in the FIR.
For that purpose, my lord, his custodial interrogation required, my lord.
No, my lord.
So
I am
plead
ready
out
to
his, my lord.
comply. I am ready to comply. I am ready to cooperate, Your Lordship.
Property is there, my lord, but otherwise it will not be recovered, my lord. Stolen articles not be recovered.
Nothing has been recovered till date. I am ready to cooperate.
He's absconding, that's why it is not recovered from
Absconding.
his
He is under fear and anxiety that he may be arrested. His family is under fear and anxiety.
He has
The
committed
way
the offense,
the
that's why
way the
he is
police
in anxiety,
officials
my lord.
have
Otherwise,
had a
no
conversation
one
with the
can
family.
take the
He is
name of the other person, my lord, without
under
having
fear
any,
and anxiety.
without having information knowledge.
And for a common man, it's very common to have this fear and anxiety. We are ready to cooperate, my lords. The accused is a habitual offender. His statement may not
He is
be
also a
credible.
habitual offender, my lord.
No, we are not habitual offender. I am not
Earlier
habitual
occasion also
offender.
he has received
The police officer had said, the police authorities has said that the accused is a habitual offender, but none appears on record saying that I am an habitual offender. None.
What about the CDR records are there? Are the arrested accused known to you?
No, my lords.
Also known to them, my
Only on the basis of the statements I've been dragged into this.
If they're not known to you, where did they find your name?
lord. And led to the
My lords, we are from
house
the
of
same
my-
district. I'm having a hardware shop in the same district. Maybe
Jewelry shop-
in the earlier occasion, he have come to my shop. It
Jewelry
may
shop
be a
also there.
transaction, and now he has dragged me into this matter. I'm a victim of the circumstances, man. That's it. And it is a matter of trial. We are ready to cooperate. Malak. Lordships allows, I'm also relying upon one judgment, similar facts, Malak. Judgment delivered by the High Court, Honorable High Court of Delhi, though it is not binding upon this Honorable Court, but it is a value, Malak. Similar facts and anticipatory bail has been granted in view of the same judgment, Malak. P. Krishnan on Reddy versus the state of Andhra Pradesh. Similar facts.
They have come down from the railway at Rungia Malad. Thereafter went to the house of the Malad present petitioner Malad and sold it at rupees 1,80,000 Malad, and they have divided it into Malad. Earlier also they have sold it to the present petitioner Malad. CDA also said that they are in contact with the present petitioner Malad. Yes, Malad is the Malad person who sold Malad. Only not
Already see. Portion of the judgment of the High Court, Honorable High Court of Delhi.
Just give the paragraph.
Paragraph number 7.
7.
I have a
Seven.
strong objection, Malad, in this case, Malad.
My humble submission at this stage, bail may be granted, Malak. This is my most humble and respectful submission before this.
Yes.
I'm so grateful. Malak. Yeah, please, Your Lordship.
Okay, no? See. Malad, today's CD notice in Malad. Service complete, Malad.
Also case friendship.
Repairing. Not received.
Nasil. Last date of Nasil.
But the last date CD already received.
On 30.
Huh?
30, 36 CD was
Yes.
received. Thereafter, on previous date, PP has no knowledge about the CD.
I will take instruction, Malad, but the CD is available.
If Lordship CD is returned, then CD may be called for Lordship.
I'll take instruction, Malad.
Last occasion also PP said same thing was submitted by the learned
CD no
Lordship.
Learned, additional PP6 some time to obtain instructions regarding availability of the
Malad.
CD. In case CD is not available, same be called for. List the matter again next week. Give it date.
Malad. 29.
I'm obliged, Lordship.
We are on interim.
Malad, here charge sheet submitted, Malad.
We are ready to appear the trial court if the honorable court may be protected.
Learned counsel for the petitioner, learned additional PP submits that CS has been submitted by
Charge sheet number 494 of 26, dated 19/7/26.
counsel for petitioner submits that he shall appear before the learned court below. Apply for regular bail. Accordingly, this petition is disposed of with the direction that the petitioner shall appear before the learned court below within 14 days from today. Till then, the interim order dated 10/6/26 shall stand extended.
Briefly apply.
My lord, here also CD not received, my lord, there interim, my lord.
CD not received. Team to continue. List again.
There on interim, my lord. 10th of August, my lord. Thank you.
Yeah, please, Lordship. 483, 482 application, Lordship, is on interim. He has appeared before the IO, also his statement was recorded. Basically, false promise to marry. They were having a relationship, and because only problem is that the parents did not accept their relationship. So she was thrown out. Thereafter, she has filed the FIR. FIR also final page 15. Statement has been recorded.
Appeared, my lord, statement recorded.
Dated 9. Line to lead, moreover, FIR lost 20 days. Pursuant to interim section granted by this court, the petition appeared before the IO and his statement has been recorded as revealed by the CD. That are having regard to the nature of the allegations. The prayer for pre-arrest bail is allowed. Order of hearing pre-arrest bail dated 19/6/26 is hereby made absolute condition.
Obliged.
The non-FIR, pre-arrest bail, non-FIR, Lordship.
My lord, I have received the report, my lord. No any case registered against the present petitioner.
Alternate additional PP has furnished instructions received from the of Jogi Gopa PS stating that no case has been registered against the petitioner. The said police station petition stands closed.
Okay, 7 also, my lord, report. I have received the report, my lord, no case.
Which police station?
Mukalma police station.
Same order, Mukalma police station.
Okay. 48, 49, 50 and 64, my lord, same CD, my lord. Is there received, my lord? But here in this case, my lord, IO is trying to, otherwise sufficient materials is there against the accused person, my lord. IO is trying to collect the medical report, my lord. Medical report, injury report not yet received, my lord. Because there are some grievous injury regarding, my lord, fracture of leg is also there. So injury report is, my lord. Sorry, my lord.
May I, my lord? My lord, in this case, my lord, there is a land dispute between the two persons, my lord. One is the petitioner number 2 and the Refazuddin. So he is the husband of the informant, my lord. Due to the land dispute, my lord, the said Refazuddin, my lord, illegally possess a land of measuring plot of land
All that has
measuring.
been heard and then the CD has been called for. CD has come, but we need the injury report also, I think.
Till then, my lord,
Considering the nature of the
it
allegations.
is a land dispute, my lord. There is a cross FIR, my lord. Both are found to be true. Ultimately, my
Yes,
lord,
all that has been recorded here while calling for the CD.
Yes,
but
my
no interim was granted.
Yes, my lord, that is why my lord, short date was given, my lord. But my lord, on the last occasion, my lord was not, my lord, due to some unable circumstances, lordship could not be seat, my lord. So, my lord, this matter is listed today, my lord. That is why it's on that day, my lord, a short date given, my lord.
IO is trying to collect
Immediate after the opening of the
jury report, my lord.
first date of the opening day of the honorable court, my lord.
In the CD, what is there?
CD, my lord, statement of eyewitnesses is there, victim's statement is also there, my lord. And
So your best chance is the injury report now. Otherwise, we can dismiss it today itself.
No, basically, my lord, there is two FIR, my lord. Both these FIR registered under the same sections, my lord. Once my lordship may peruse the FIR, my lord.
Now we
Our
have
FIR,
told
my lord.
you, what is your choice?
But I am wait to for my chance, my lord, next chance.
84950 CD has been received, but injury report is not available. It is submitted that injury report will be necessary for adjudication of the instant application. IO is directed to produce the medical report by the next date fixed. Tuesday?
Tuesday, my lord. On Thursday, my lord, would be convenient.
All right, Thursday.
Then item number 49, lordship, and the petition
48,
number 1 is
48,
interim,
49, 50 and 64.
64.
64 supplementary cause list, my lord. 64.
64.
lordship. Item number 49, lordship, the petition number 1 is all interim, lordship.
Huh?
Item number 49, lordship.
49 interim order passed earlier in respect of
Petition number 1.
continue till the next date of listing.
What is my lord?
Currently, Peru's order dated matter 29/1/2026, passed by the Logima. 29/1/2026, madam. She has got it. It's reflect the service upon the respondent number 2 and 3 has been complete, my lord. Next page. And 1 has already appeared.
Now what is appearing?
1 has entered appearance, my lord. Her name has been reflected in that call to person. But the matter is ready for, LCR has also been come, my lord. It is ready for admission. Twenty-nine 1/2026, my lord, passed by Joint Registrar Judicial.
Where is that? We are not finding it.
Is there in the order sheet? So I've checked it.
Lawazimar order to quotation.
The order sheet itself serially is there.
Order sheet of Lawazimar.
29/1/26.
What does it say?
It said, my lord, I'm handing over the copy of the order, man. It's there, I have checked up. I can help you out. Last page, it has been.
Being service completed 2 and 3.
Yes, we have checked up, my lord.
Who are 2 and 3?
2 and 3, my lord, manager of the bank.
So what is the case about?
But it's case is about, my lord, initially the bank, my lord, mortgage sold the mortgage property to us, and they took a huge amount of money, and thereafter, my lord, they did not execute, my lord, sale deed, and rather they have handed over to the respondent number 1, my lord.
Third learned counsel for the petitioner, learned additional PP. And appears for respondent number 1, although name of learned counsel is shown in the counsel, Miss S. Bora is shown in the cause list. As per order of the Lawazima Court dated 29/01/26, service of notice upon respondent numbers 2 and 3 are it. However, none appears for the said respondents. Is the matter for admission.
Pray for a date, also.
Yes.
May I please, your lordship? Lordship, the matter may be adjourned for the day. After checking the office note, I come to know that step has not been taken.
Counsel for the petitioner prays for some more time to take steps. Prayer is allowed. Please take in weeks.
Hello.
It please your lordship. On last occasion, my lord, the learned PP may have to bring instruction, my lord, with regarding to taking steps on 18/9/2025, my lord. It is given.
Lordship, notice is served upon respondent number 2, Lordship. Anjana Sakya.
What is this, POCSO?
Oh, yes.
And for
For the petitioner, learned additional people submits as per instructions received that services affected upon the respondent number 2, but none appears. Said respondent. Accordingly,
Report
Then
will be
so-
kept as a part of the report.
is there Miss Porasar, the Porasar is appointed as to represent the respondent number two copy served upon newly appointed amicus
Dashboard, yes.
matter on
Six of
petition of IO of the OC. The communication decision. You have given any communication?
Yes, Lordship, that may be kept as part.
Communication furnished by. Yes, be kept on record.
My lord, before date, my lord, on 7 August, next date is fixed, my lord. Obliged.
Regarding respondent number two, service report is awaited also. ECR is yet to be.
You've taken steps.
Yes, Lordship. Trial has been progressed, Lordship. Framing of charges, Lordship.
As per office note dated 20/07/26. Press notice on respondent two has been issued by Eastern 09/06/2026, but neither ID card nor unserved notice has been received back. This is in 1 month ago. Petitioner may take steps for service of notice through concerned police station by putting it through the registry list again on.
Lordship, regarding TCR, Lordship. Call for reminder has been issued, Lordship.
This year also not received issue. Reminder once again.
Right.
Please, Lordship. Lordship, as per the office note, neither the ID card nor the answer notice has been received. But the steps was taken in the back in the month of March. So, Lordship, may I pray to list the matter again in the month of first week of August and kindly call the tracking report by this time, so that we may ascertain whether we require to take fresh step or, any other measure.
Per office note, ID card nor unserved notice in respect of respondent number two has been received. Back office note dated 18/7/26. Registry to ascertain from track consignment report whether service has been affected. Is the matter again on?
First,
Highly obliged, my lord.
Please, my lord. My lord, in terms with the last order, my lord, the Dusty service has been affected on the respondent number two, my lord. The affidavit regarding the service of Dusty, my lord, has been filed only today, my lord. So that is not there on record.
File the wakalatnama by today. Lordship may file the
You
affidavit.
are appearing for respondent
Respondent
two.
number two.
At council so and so has submitted that she is appearing for respondent number two and will be filing. So you have filed.
No, we will file
Wakalatnama
the-
you have filed
Yes, wakalatnama we have.
and has filed Wakalatnama. Takes some time to file counter affidavit. Hence list the matter again on.
I know the interim may be extended, my lord.
Is extended till the next date of listing.
Grateful, ma'am.
Please, Your Lordship. As per the last order, Your Lordship, we have taken the step to the the informant, and she has received the step, and she has filed another affidavit regarding the quashing of the FIR.
But in this case, those services not complete, they have challenged them at FIR. Now, police has succeeded the case, madam. Investigation complete, madam. There are materials. He also there, earlier CD was there, madam. There is a report also, madam, today we have received. But search is submitted, madam.
So TCR is to be called for.
Materials are TCR, madam. As far as CD, you ask, madam. Nowadays, madam, CD, one copy has been sent, madam. CD which has earlier, madam. Today we have received a signal, madam, search is submitted, madam. Teacher call for, madam, they have not challenged the search sheet. They have to challenge the search sheet also. And there are materials, madam.
Lordship, Sashi will be submitted after we have filed this quashing petition, Lord. And I'm been appearing, we have filed already, I have filed already Wakatnama in trial court below, Your Lordship. And she, the informant has already filed another affidavit, Lordship. Kindly.
In that case, one affidavit, madam, in they have annexed in the petition also. Madam, in
During
that
the
case,
petition.
but they may be here before the.
I have already filed Wakatnama, Lordship. Trial court below.
Government may come here and or appear before the court below, madam.
Lordship, informant stays in Pune, Lordship.
He has sworn in affidavit and sent it. He is in Pune, but has sworn the affidavit in Haflong.
Was in Haflong during this caller.
But the affidavit has been given by the petitioner's counsel, madam.
No,
Original copy. But what is it's a compoundable offense?
Under section 7, no, 70.
Is the nature of the allegation?
Went to, he's a bank employee. Petitioner went to his chamber for SBI, you know, some difficulties were there. When she provided the mobile phone, he shared some photograph from the mobile phone of the informant to his mobile phone. And subsequently, he through WhatsApp. And subsequently, he has deleted the same also. But that photographs, private photographs, remain in the mobile phone of the petitioner.
If the bank visit was on 26 February 2026, she discovered the incident 8 March of 2026. Then she lodged the FIR on 12 March 2026.
Lordship.
He admitted the same also. In a statement, he admitted the same also. I have done this.
Compoundable also.
Let us have it there for admission so that if possible, we will dispose of.
Well,
in the meantime, we can call for the TCR also. It may be helpful. Heard learned counsel for the submitted that chart sheet has been submitted, white CS number so and so. Call for the scanned copy of the TCR. Counsel for the petitioner has also submitted an affidavit original by the respondent number 2. The same be kept on record. Is the matter again on
Compoundable.
if not compoundable, we can exercise jurisdiction.
May I please, Lordship? Lordship, kindly adjournment the matter for today, Lordship. My senior is out of discussion, Lordship.
That is all right. This is for order. Let us see why it has come. Please.
Due to his illness, he is out of station.
Any instruction through office, through PP, notice on respondent 2.
Sorry, Malak, that notice instruction is not received, Malak.
PP submits that instructions regarding service of notice are not is not available. Counsel for petitioner also prays for adjournment and list the matter again on.
Lordship.
I'm 65.
And appears for petitioner. List again after 2 weeks.
Please. In this case, my lord, in the main case, my lord, Lordship has granted interim bail, my lord, on 40 or 7 days, Lordship, which is poor, Lordship. The ground of my father is in the remain, my lord, in the still critical condition. So, my by this I pay for more time, Lordship.
Tomorrow is the date. Correct.
Tomorrow, my land is below, my directed to surrender, my lord. At least, my lord, more this. Lordship. Interim pair.
You're granted bail on medical ground.
Lordship. At present, I am with my father, Lordship, in the mid. Directed, my lord, there is a my lord, within yes, from the date of my lord, the main case is there, Lordship. Date of release, my lord, I will 7. Price pass on my lord 14. This will complete tomorrow, Lord. Signed a Lordship.
It is received. Otherwise,
The notice.
Observe as my lord till the CD, Lordship.
No, one date may be.
matter is anyway to be listed on 24th.
I have to sign that tomorrow. So till the man present, I am now with my father.
When were you released?
16. In 7, my lord. Lordship passed this order on 40. 35 propagation, my lord. After my lord, this will be my lord tomorrow.
So today is the last date. Tomorrow you have to surrender.
Yes, Lordship. That is why my lord. In my lord, on humanitarian ground, considering my critical condition, observe that my lord, in the receipt of the CD, Lordship, that may be observed. Otherwise, my lord, surrender will be in the hospital.
No, regardless of CD, you were given 7 days to see your father, not to take care of your father.
Still, my lord, I am with my father, my lord. So, my lord,
So you have seen your father, now go back.
my lord, I have to arrange my lord money and
That time you said he is going at any time. That is why.
no, my lord, still my lord.
Last time I have to see.
What am I?
Now after seeing, now it has become take care.
No, my lord, my money problem is there, and Lordship just just pay Lordship the receipt of the CD. If my lord, something found, Lordship, I may be rejected builder. So my lord, the surrender. Something found, my lord, I will be rejected. I will need to go to the jail, Lordship.
That is a submission when if for merit bail. But if something found, then that is a different issue. We did not grant you interim bail for that reason.
Again, my lord, on that's Lordship.
In that
List this matter on 24/7 along with
same day, my lord.
PA 1865 of 2026. The order of interim bail for 7 days is extended by another 7 days from today.
I may be disposable. I am disposable.
Let it be on a pending, my lord. If
Let it. We have said list it along with BA.
I'm deeply obliged, Lordship.
Please, Your Lordship. Here, the petitioner, this appellant Lordship, he was convicted for
3 years under section 419 of IPC, and he was convicted for 7 years under section 4 of the POCSO Act, Lordship. This man was arrested, Lordship, on 15/10/2018. 15/10/2018. Since then, he is in custody. During trial also, he was in custody, Lordship.
He has crossed 7 years.
Yes, I think he has crossed 7 years, Lordship. But we have no instruction, Lordship, whether he has been released from jail or.
Kind of a case is this? Mr. Spencer, learned counsel for the petitioner, submits that the sentence is for 7 years, and the petitioner was remanded to custody on
15/10/2018, Lordship.
and he has no instructions whether in the meantime the petition appellant has been released on bail. Which jail is this? Which district?
It's Borpeta, Lordship.
Borpeta. Call for a report from the superintendent. Borpeta is district jail or central jail?
District jail, Lordship.
From of district jail Borpeta as to whether the appellant so and so. What is the name?
Kobir Ali, Lordship.
Kobir Ali is still an inmate of the state jail. Connection with what is the case number?
His session's case number.
Sessions case number.
Lordship. In the appeal memo, Lordship. It is special POCSO case number 18 of 2018, Lordship.
1 week should be sufficient.
It will come to registry.
Hmm?
For registry, it will be easier, my lord. First type of my lord, report from the
Registry to call for a report.
file. It will come within a week, my lord.
So and so. Please again next week. Okay. Next Wednesday.
Lordship, revision petition is preferred against the order dated 10/5/2023, whereby my Zimba petition was rejected by the learned trial court. Initially, I filed actually the respondent took some of my items, hangers items, from me, bound for her. He went to Aizawl. There he came back. He did not hand over a complete 10th item to me. Steel hangers was written by him. Thereafter, I lodged an affair against him. And he also lodged an affair against me. In that affair, the sum of the items, steel items, were kept with him, as because there was no space in the police station.
Where is the impugned order?
Impugned order at last is at page 67 to 72. 15 impugned order.
What is this iron frame?
It is steel structure.
Where is it kept now?
It is with the respondent. The case, his affair has already been, his case has already been first filed. Final report has been already filed. and that was accepted by the magistrate. There is no case against me now.
My lord, here several persons are from the respondent side, my lord. Since in the
I see somebody on the screen.
Lordship, I am appearing onto the response number 1, Lordship.
Who is one?
Ranjan Barpatta Gauhati.
He is the informant of the case against which FIR the present petitioner is aggrieved. They filed a Zimma petition against the FIR filed by me, and the Zimma petition was rejected by the Honorable Court, and now they are before this Honorable Court, Lordship. And may I submit, Lordship, one thing? And Lordship, what happened actually, the entire dispute between the parties is a civil in nature, which is rightly observed by the learned court below when disposing the Zimma petition. And secondly, my lord, the ownership of the articles, these articles claimed by both of them. The petition, the informant, the respondent number 1, also claimed that he is the owner of the property, and the present petitioner, the Zimma petitioner, he also claimed that he is the owner of the property. My respectful submission before your lordship is that while deciding a Zimma petition by a court of law, then the duty of the petitioner to prima facie satisfy the court that he is the owner of the property by showing some proper document before the court. For a moment, if your lordship peruse the annexure 1, 2, and 3, these are the documents submitted by the petitioner before the trial court that he is the owner of the seized property. Now, whether the annexure 1, 2, and 3 are sufficient document to prove the ownership, the same thing is observed by the learned trial court also. They are annexing a trade license, a copy of challan, and a blank document challan from their own firm. These 3 documents are the documents before the trial court, and the petitioner claiming that he is the owner of the seized property. So, for that reason, the learned trial court observed, if your lordship peruse the impugn order, the page number 70, lordship, in the middle of the paragraph, in support, for a moment, lordship, kindly peruse, page number 70, in support of his ownership, that is, the petitioner has annexed a copy of GMC license, delivery challan number so and so, dated so and so, specimen copy of delivery challan, and workmanship certificate dated so and so in his petition. And those documents are not sufficient to prove, because I am also claiming, if in my FIR, there are 2 FIR. One FIR, annexure number 4, is filed by the present petitioner. Annexure number 6 is my FIR, where I also claiming the same, that I have purchased those documents from him, and thereafter, out of the entire seized article, some articles were taken by the petitioner already. He has already taken the articles, and rest handed over to me by the police, because such huge amount of articles cannot kept in the police station. I claimed it, and the police handed over to me. I am not disputing the same. And the thing is that, my lord, whether the thing is that by filing a Zimma petition, whether the present petitioner can claim those seized article belongs to him. The answer is no, my lord. So it is a civil dispute. If he approach the civil court, I have nothing to say. But the thing is that this is the only petition to harass me only. And once this Zimma petition was disposed of, thereafter they approached before the Honorable Sessions Court. Now Sessions Court remanded back to the again to the trial court. Trial court disposed of the matter rightly, lordship. If your lordship peruse the entire judgment, then lordship will find there is no infirmity on the part of the court, lordship. This is my prayer, lordship.
Lordship, my submission is this. Apparently, he claimed to purchase the property. There is not only it is oral statement. I have a document to show that he took my items up from me. So my documentary evidence will prevail over his oral statements. 1, 2. And except 2. Secondly, Supreme Court has given a judgment. It is only that 451, there is a specific provision in criminal revision petition, criminal CRPC. By that also can be disposed of. It is and since 2015 it has been lingering. Now only back end of 2023, when by already revision petition already are over, that is a civil dispute. So how can I recover? By the way, it is perishable goods. So I have steel items are generally perishable. So I have suffered a lot. He is only under his petition, his FIR has already been given, final report has been given. So there is nothing left in the FIR.
Lordship, my learned friend submitted that they have some document to prove their ownership. Let him produce that document.
What
Let him
else
mark that
document is required? I have a
which
trade license. I have
which document, whether the trade license is sufficient enough to prove that I have the owner of the particular goods. Is it so, Lordship? Trade license.
Annexure 2 at page 18. It is a
Lordship,
delivery challan. He took it,
Lordship,
he signed it and took it. Nothing more is required. Delivery challan is enough.
where is my signature, Lordship? Where I have admitted that that signature is my signature.
Signature is there in the annexure, that is annexure part in the handwritten this one, at page 19. I like to refer in the judgment of the Honorable Apex Court.
Lordship, may I kindly see the page number 19. This is their document.
All right.
Where from?
My items, my document will be only there. Whose document will be there?
Yes, this is their document. Lordship, may kindly, for a moment, kindly peruse page number 19, annexure 2. Lordship, may kindly see whether this is a proper document to say that those sales articles belongs to him. Where is my signature? I have not found the signature of my client anywhere in the document. They are claiming that there is my signature. Where is that?
No, signature.
It is not an admitted document.
Has this document been dealt with by the court in the impugned order?
No.
Yes, Lordship. The learned trial court peruse each and every document annexed by them. This document was also annexed in the Zimma petition. After perusal of the same, the petition was rejected. If your Lordship may kindly peruse the last portion of the impugned order. The learned court below rightly observed, Lordship.
So once the final report has been accepted, the case is over.
So there is his claim that he purchased the item, does not hold good.
No, after that, does that court retain any jurisdiction to decide on
Lordship,
the
only
Zimma?
thing, if court does not have the jurisdiction, court has that, apparently it was that custody was given to him. He is a custodian till that time.
No, police gave him custody.
Police has gave him custody.
Now, if you want it back, where does your remedy lie?
Even civil, by the time the order was passed in the year 2023, it is more than 8 years, 11 years past. How can I go to the civil?
That's why they are before your
The
Lordship.
civil?
They know they have no any remedy before the civil court. That's why they are dragging this matter and harass me, Lordship.
No,
nothing else.
it is not the case.
And since inception, Lordship, the ownership of the property is in dispute. They are saying they are the owner. I am saying I am the owner. Whether the criminal court can decide it, Lordship, in a Zimma petition, both of us, we have to go to the trial court or a civil court, competent civil court to decide the issue, Lordship. They know they have no time limit to approach the civil court. That's why they just dragging the matter time and again, Lordship.
First of all, he claimed to have purchased the documents of items. Where is the document to show that he purchased it?
You are the Zimma petition. First of all, you show that you are the owner of the property.
7 lakh. He claimed that he purchased for paying by rupees 7 lakh. By which mode? By which document?
All right, Lordship. For argument's sake, I admit it, but not accepted that I am not the owner of the property. He is the owner.
That's
so
all.
let
That's all.
him prove. Let him prove
Let's
that whether the trade license is good enough. to before a competent court of law to prove that I am the owner of a seized article? Whether municipality corporation can, by issuing a trade license, giving a ownership of a particular article? No, they are showing a chalan of their own. That is not an original document, it's a Xerox copy. They don't have the original one, and Lordship, they are saying that there is a signature of mine, whereas I have disputed throughout the time. There is no signature of my client.
Signature is there in the page 19. There is a short signature is there. He has once he has admitted, yes, it is his not the items, then it becomes my item. There is no third person.
I said ownership is under dispute. I am also claiming the ownership.
When you dispense with your ownership, then it becomes my property.
Who said I am dispensing with the ownership? I am not dispensing with. I said for arguments that if for a moment if I accept it, even then they cannot prove it, Lordship. It is their duty, they are the petitioner in the Zimma petition, their duty to prove before the competent court of law that those seized article belongs to them. Under section 451, Lordship, also interim custody given to a person who can prove before the court that he is the owner of the property. Whether the present petitioner can prove that part before the court? No, Lordship. The learned court below rightly observed that they failed to prove. That's why it's a civil dispute.
Out of annexure 2, half of the property has already been given to me. I am retaining that property, and another half or still structure has been retained by him. And I have a document to show that he has signed it. Now I like to refer a judgment of Honorable Supreme Court in this regard. What the 451 can do, custody.
Whatever document you have, is it on record?
It is on record, because that's what Chalan is given. Chalan will be given to him because he has to carry original, he'll carry it. By default, he cannot claim it now. Only thing, I do not know if I can succeed getting the things also at this stage after 11 years. I do not know what is the position of those items now.
Yes. This is Ambalal Desai judgment. This is regarding 451. Is during pendency of the trial.
Lordship.
Here there is no trial. Final report has been accepted. So 452 may come into place.
Yes, Lordship, that yes. Actually,
but even for that purpose, what is the basis on which the question of possession is to be decided by the magistrate? Whom to give custody?
Custody, it was given magistrate custody at the time. Police took it of its own because they says they do not have
now
space.
on what basis magistrate is to give you? That depends on what documents you can show.
Even he could not show any document. Now those items, it is a.
That is why if nobody can show anything,
I have a document to
magistrate supposed to do.
At least it is enough that it is in his custody now.
No, it is in his custody, but for it to be given to you,
yes,
you have to make out a case.
I have given a document that what is it called? What Chalan? Chalan is there.
Now, what is the finding of the magistrate?
Magistrate finding is that it is a civil dispute.
No, it specifically with regard to the Chalan.
Chalan nothing has been specifically stated. Nothing has been specifically stated. The Chalan is not a document of proof.
The Chalan is itself under dispute, Lordship. They are saying that I have a signature. My client put a signature there. Throughout the time I am disputing that this is not my signature. So how can they say
a full-fledged trial is required and the matter is a purely civil in nature? This order was passed in the year 2023 when my petition stayed there for a long time. The civil in nature, the court, if the court should have merely saying that I am not protected by the section 14 of the Limitation Act also. I have a valuable property. Even he admitted that it is 7 lakhs property. So why I should suffer because of his fault? And his case is not there. His case is already, final report has been already filed against him.
In my affair, they have filed a Zimma petition, Lordship. The petition was, they are the petitioner. That is their duty to prove before the court of law that the property seized by the police is their property, they are the owner. They fail to prove by showing some. Lordship may, again, Lordship may kindly peruse the page number 19, Lordship. Merely on the basis of this document, whether they can claim that ownership, Lordship. Whether they can produce some bill or some cash memo like that they purchased those documents.
On the basis of Exhibit 2, Annexure 2, I already got 50% of the property, tentage items. Only the steel section I was not getting it. So that's
How they receive, Lordship? How they receive? At that time, they filed an FIR before the court, Annexure number 4. In that particular FIR, they filed a Zimma and they took the documents. I was not aware at that time. And those documents, those articles shall not belongs to me. These articles belongs to me. Whatever they receive in other Zimma petition, I am not concerned with that. That's why I am not agreed before any higher court of law.
No, I am still trying to understand this page 19. What is this? Precept network, Gauhati.
Yes, Lordship.
Kind detention, Ranjan Borgohain.
Oh.
Hangars, 15,000 square feet, 1, 2, so and so, 3, so and so, 5, so and so, 6, so and so.
Lordship.
Then
this is a document
signature.
produced by them, Lordship. I am Ranjan Borpatra Gohai and I am the proprietor of this firm.
Annexure 3, let us come to the Annexure 3 at page 20. It is his, this one.
It is blank document, Lordship.
It is
absolutely blank challan. How, what they are trying to prove, I don't know. What they are trying to prove, I don't know. It's a blank challan, their document. This is a blank copy of challan, their document. What they are trying to prove, I don't know, Lordship. That's wasting the time of the honorable court.
Original copy, it is a photocopy they are given. It is a photocopy. Annexure 2 is a photocopy of the carbon copy. In a carbon copy.
All right, photocopy of a carbon copy, but I am trying to ascertain what it means. Explain to us. We are not traders. We don't know.
Lordship,
My lord, kindly see page number 20.
It's a blank document.
This is delivery challan. So prior to that, this was the delivery channel. Only that he takes the original. I keep only the carbon copy of the same.
The carbon copy should have some contents.
Contents with
Specifications, quantity, product code, amount. Are these supposed to be left blank?
The carbon copy is not like that original. This is just blank paper.
Kind of submissions are you making?
It's a blank paper.
Are we supposed to imagine some figures and descriptions here in a
That's
blank?
why I given the
challan?
specimen of the same. Specimen of the same. Which is Annexure 3. Because earlier what about only one copy was the earlier, this second copy was a blank. So our first one we write the carbon copy, and after that only we have written the precept network Gauhati and given to the Ranjan Bhagat. He has signed it. And out of all items from number 2 to 6, I have got Zimma. By filing a Zimma petition, I got the Zimma. Only structure of 1,500 square feet, that is 400 square feet. That is 440 kg. That is steel structures.
I have got Zimma because nobody objected.
No, there is a full hearing you and I applied for Zimma petition. This full hearing was done.
Where is that order?
Yes, order is. Order is 52 to 54. Somewhere it is there.
Who is Ranjan Borgohain is who?
Respondent
number 1 is Ranjan Borgohain. I am appearing on behalf of him. He is the informant in this case. In that FIR, they filed a Zimma petition.
So if this is what you claim, the typed copy, page 18, typed copy of delivery challan.
It's not typed copy exactly, because generally we have got the original copy.
Look at page 18. We are reading page 18.
The type copy, yes, sir.
Yes. So, precept network, Gauhati, kind detention, Ranjan Borgohain, hangar, so and so. What do we make of it now? Where is the
This is
signature
type
that he
copy
has
of-
received?
Your Honor, this is a type copy of Annexure 1. So I have.
So
only
Annexure 1,
Annexure
what
2,
is
Annexure
thought to
2.
be conveyed by Annexure 1?
Whatever is there in the Annexure 2, that only I have typed because I have the right to type only those things, not the
Yes.
beyond that. Because already I told the Annexure 3 is our specimen copy, and beyond that only one blank paper is there where we put the carbon. At that time it was of that.
I
Bona
cannot
fide
make
of
any
hiding
sense
here.
out of it.
There's no hiding from our side.
What is the meaning of this? We are asking you. We are not telling you that you are hiding something or doing this.
No,
We
what
are
I
only
want
on
to
your
try to
document.
submit-
What do you want to mean by it?
That is, we have given to the Ranjan Barpatra Gauhati hangar, 1500 square feet, one, triple, and blanket, rope, Dunlop, lights, ladders, wooden. These are all the items of one pendle. Out of that, we got the rest of our item except the steel structures. That is also I have
So
filed.
whose signature is? There are two signatures. On the left side, there is one signature.
Right hand side is a Pankaj Majumdar. Pankaj is clearly visible. It is a
Who is he?
petitioner.
Is the petitioner?
Yes. Left hand side is signature is that is Ranjan Barpatra Gauhati.
No, Lordship. I'm
Who
disputing
received
the.
Yes.
Who received this by way of this page 19? Who
Yes,
received
he
this?
himself has received.
Huh?
He himself has received. By
Ranjan.
signing the chalan. There's
Ranjan has
at
received.
least we have got one document that is he has received. What he has purchased for 7 lakhs, but he has not produced any document. Is it possible? He'll purchase from me and without any document. This is at least one document we have got related to only circumstantial documents are there. At least we could prove that this is, he will definitely deny. Definitely he is going to deny that this is not his signature.
My respectful
I will
submission,
admit it.
Mr.
I will
Lordship,
admit
is
it.
that
And moreover,
Lordship, my respectful submission before Lordship is that they annex annexure number 1, 2, and 3 in their petition to prove the ownership of their seized article. Lordship may kindly have a look
yes,
whether annexure number 1,
Lord.
2, and 3 is sufficient enough to prove their ownership, Lordship. The answer is no, Lordship.
My lord, we
With
have to see
this-
both the side. We have to leave both the side. Yes, I have at least I have produced some document. And I have produced my trade license also that I am doing that business.
It
I
is
have got
the
a copy also. And his signature is there. Definitely he's going to deny. But what about him? At least he
it
should
is a-
show something. And
it is
already
a
half
trial
of the
court
item I
to
got. How I got?
satisfy. Lord.
Already half of the item I got.
He received
Also-
that articles from his own FIR, Lordship. He
No,
filed
no,
a Zimma in that,
My
and
lord,
he
I
is
just showed out. No, my lord.
he received half of the articles from against his own FIR. And Lordship,
Yes,
what I'm
kindly see 40, page number 40, 48, 49. 49, kindly see the 40 operative part. What is made apparent via Caesar list and reports so filed is that Jimma petitioner Pankaj Majumdar, that is the informant complainant, already received the Jimma of the articles seized in this case. It's already given the Jimma to us. Hence, in view of this said position, petition number 2905 has been rendered in redundant. Same stands off accordingly. So this is the order of the honorable court. Given because initially item was given because generally it's a trend of the police people that whoever the item is given to the informant, not to the other, not to the accused.
the article which received by them, I am not disputing that. I am not the owner of
And moreover,
those
he cannot say
articles.
now, he cannot say that he was not present at that time because it is already hard decided. Once half of the items will be given to us, why not? But we did the same documents. And 2015 itself I got. Now, because want of
Articles, I am not disputing
why it
that.
can be denied? For want of some document, why it can be denied at this stage, my lord?
I am the owner of the hangar. That's why I am claiming the hangar
Oh, yeah,
only on the
not
police.
owner of the hangar. Where is that? Where is that? Where is the document? Simply giving verbal submission will not do, my lord. Amount over 7 lakhs. He's claiming the 7 lakhs, alleging the 7 lakhs he has purchased from me. That is
My
what he purchased me. I was the owner once upon a time. Now he purchased. You show some document. At least I have got some documents. I have got the orders. It cannot be said that court below has given the Jimma petition, Jimma of those half of the articles without considering the facts, without considering the documents.
May I submit, Lordship? My responsible submission is that, Lordship, that he is the Zimma petitioner against in the FIR filed by me. It is his duty to prove his case by showing some prima facie document before the Honorable Trial Court that he is the owner of the says article. How he can expect that I have to also prove the same? The trial court said that he failed to prove by giving those documents is not satisfactory and not sufficient to prove his ownership.
No, my lord, no, this is not failed. Nothing is there in that order. Only it is a civil nature.
Civil nature.
Only civil nature. Nothing else here, my lord.
And lordship is
I
that's
have
why
these
I'm
documents.
saying that
These
that
documents,
may
I
be
got the
that
Zimma,
may
half of the items.
it may be a dispute
And
of
I
civil
got
nature,
half of the
lordship,
items.
but they know that they cannot now approach before the civil court. That's why they are dragging the issue time and again, lordship.
No, my lord, it is not the one. Because
this is
2015
their
onwards,
duty to
I am
prove.
struggling for the same. 2015 onwards, I am struggling. More than 11 years past.
He is also dragging me to the court since 2015, my
Only
lord.
half of the item. And whereas already I have got the half of the item from the court below. And that cannot be said that that is down wrong. That they should have come for revision. They have not come. They are accepted. They came to know that half of the item I got.
I am not disputing that. I am not owner of that particular articles. That's why should I claim that
He's telling
article?
that I have purchased a pendle. Now he's telling that only structure. Half of the item only structure.
It
So it's
is
still
absolutely
structure. Not
civil
the
nature
pendle.
dispute,
Pendle
lordship. Zimma
includes everything.
a Zimma court cannot decide, my lord.
Include everything, my lord. Structure as well as tirpal, tin, bedding, wooden blocks, hammer, everything.
All right, we'll, I think, have to try to understand it better because I'm still finding it some difficulty to understand what are the purport of these documents we have submitted.
Lord, I'm learning for last 11 years for getting the half of the item. Only on the structure.
Actually, at least one part of we have already so that we are the real owner.
How can with which document, lordship? With which document? Annexure number 2.
Let it come for again here.
Annexure number 2, lordship.
All right, we'll hear again.
Lordship.
Just again on hard at length. Again on.
I do not like to trouble your lordship today, but I would like to point out one thing regarding item number 25. That is, yes, no, regarding that default bill in Rakesh Paul's judgment. I may be wrong, but I would like to point out your lordship one aspect. Yes, no, one. Only the only relevant portion. That judgment is from 1 to page 80. So 30, my lord, 2, my lord, last page. If my lord maximum 2, 3, 2 and 3.
Last page, my lord.
Last paragraph 30, 1, 2, my lord. Page 79, section 167.
Para 30, my lord.
Para 30, 2. Where the accused is served with offences.
Is not life or death.
Unprotected life.
Means minimum must be 10.
Yes, my lord. If my lord maximum is
provided maximum is not life or death.
In 140 is maximum is
life imprisonment. So in that case, my lord, on any other ground, my lord, he may be entitled, but default bail, my lord, he is not entitled. My lord. That case, my lord, 90 days, my lord.
Okay, we'll see then.
That word default management. There is
On any other ground.
interpretation management.
Later the detail.